The November 18th meeting of the Board of Zoning Appeals is now in session. Good evening and welcome to this meeting of the Arlington Board of Zoning Appeals, which is also known as the BZA. I am Inta Malice, chair of the board. The board is made up of 5 citizens appointed by the Circuit Court. In addition to myself, we have Vice Chair Peter Owen and members Judy Freshman, Paul Melnick, and Portia Clark, who will be joining us later this evening. Also present is the professional staff, including Stephen Rizzi, coordinator for the BZA, Blake Bowen, assistant to the zoning administrator, Mark Hamela, zoning technician, and Matt Busing, acting assistant to the zoning administrator. For the safety of our board members, county staff, applicants, and participating community members, we are a virtual meeting today, and all participants are joining remotely. We are legally authorized to hold this virtual meeting based on the governor's executive orders, legislation adopted by the Virginia General Assembly, and the Arlington County Board's Continuity of Operations Ordinance adopted in March of 2020. We thank you for being here and extend a warm welcome. Before we call our first case, I will share with you some general information about the Board of Zoning Appeals and then some ground rules on how we will conduct virtual meetings. The staff report for each case on tonight's agenda can be found on the BZA website. Staff has placed a link to the agenda in the chat section of the session. If you have not seen the report for your case, you may wish to review it before your item is called. Staff has also placed a link in the chat for supplemental material received after the staff reports were prepared. Board's powers are prescribed in the Code of Virginia and are set out in further detail in the county zoning ordinance adopted by the county board. The Board of Zoning Appeals does not have the power to rezone property or to amend the regulations set forth in the ordinance. That authority rests with the county board. This board does have the authority to do 3 things. 1, we can approve use permits that allow modifications of placement requirements for structures on 1 and 2 family lots where there is no option in the zoning ordinance to allow such modifications. 2, we can grant variances from the specific requirements of the zoning ordinance. And 3, we can decide appeals of decisions of the zoning administrator. When approving use permits, the Board of Zoning Appeals may impose conditions that it deems necessary in the public interest, including limiting the duration of the use permit. In order to approve a use permit, the law requires that the board find that the proposal meets certain conditions and that the use permit will not adversely affect the health or safety of persons residing in the neighborhood, that it will not be detrimental to the public welfare or injurious to property or improvements in the neighborhood, and that it will not be in conflict with the purposes of the master plans and land use and zoning related policies of the county. To do this, the BZA shall consider whether the modification will promote compatibility of development with the surrounding neighborhood, because the structure's overall footprint, size, and placement are similar to the structures on properties surrounding the lot in question, and whether the modification will help preserve natural landform, historical features, and/or significant trees and foliage. When granting variances, the burden of proof is on the applicant to prove by preponderance of the evidence that the improvements meet the following criteria: that the strict application of the ordinance would unreasonably restrict the utilization of the property, or that granting the variance would alleviate a hardship due to a physical condition relating to the property or improvements thereon at the time of the effective date of the ordinance, or that granting of the variance would alleviate a hardship by granting a reasonable modification to a property or improvement thereon requested by or on behalf of a person with a disability, and that the property for which the variance is being requested was acquired in good faith and any hardship was not created by the applicant, that the variance granted will not be of substantial detriment to adjacent property and nearby properties in the proximity of the geographic area, that the condition or situation of the property concerned is not of so general or recurring in nature as to make reasonably practical the adoption of an amendment to the ordinance, that granting the variance will not result in a use that is not otherwise permitted on the property or change the zoning classification of the property, and that the relief or remedy obtained through the variance is not available through a special exception process as provided for under the zoning or subdivision ordinance. When deciding appeals of the zoning administrator, the board must use its judgment to determine if the administrator was correct. The order of our meetings is as follows. First, cases will be called and a brief staff report and recommendation will be given. Following that, board members will ask any questions of staff that they may have. Next, applicants or their representatives will be given an opportunity to make comments to support the application or appeal. Next, all speakers for the item will be called. After we hear from speakers for and against the proposal, the board may permit the applicant a brief opportunity to clarify any points. The board may also ask questions of any speakers, but does not permit and will not condone any cross-examination or direct questioning by others. We have deemed the following time limits for applicants and speakers to be sufficient. 20 minutes for applicants of appeal, 5 minutes for applicants of use permits and variances, 3 minutes for speakers representing organizations, and 2 minutes for those speaking as individuals. After the board has gathered all the information they need and has discussed the case, it will decide the matter by voting on a motion duly made and seconded. A majority is needed to approve any motion. Any appeal from the decision of this board must be made.
Okay, so you should be able to see the
in accordance with state law. After your case of interest is heard, you are welcome to stay for the balance of the session or leave at your convenience. So there's a few specifics about how the evening will run since we are doing this virtually. Because we are using Microsoft Teams links, and there's also a dial-in option for those who wish to use it. If board members, presenters, or speakers lose internet connectivity during tonight's meeting, you may reconnect with us by phone. Please keep your phones and devices muted until you are called upon. Turn off sound to any other devices around you to minimize interference. For guests joining us via Teams, please turn off your camera video feed. Only board members will leave their cameras on. When called to speak, please turn on your camera and unmute yourself by clicking on the microphone icon that is located on your meeting command bar. The moderator does not have the ability to unmute you. If you are dialing in by phone, press *6 to unmute. The meeting chat is active for presenters or board members who need technical assistance only. The meeting chat should not be used for discussion, public comment, questions about agenda items, or requests for more information. All public comments must be shared verbally for the record during the assigned public testimony period. Board members, if you wish to be recognized to speak on an item, please seek recognition verbally as usual, or you may use the raised hand function. In either case, once you have been recognized, you may unmute yourself. Tonight, all voting will be taken via roll call. Applicants and public speakers. Public speakers and applicants, you will be called upon by county staff at an assigned time. Pre-registration to speak at tonight's hearing was requested. We will accommodate any additional speakers only if time permits. Public comment will take place within the time frame stated earlier, the same as what we would provide at an in-person meeting. During public comment, a speaking timer will be displayed on the screen by staff. If you are dialing in by phone and unable to see the screen, we will provide an audible warning when 30 seconds are remaining. You will be muted when your time is concluded. Lastly, this is a public forum. Tonight's meeting will be recorded and posted to the county's website. all information associated with today's meeting, whether written or spoken, is subject to the Freedom of Information Act requirements. So this concludes the introductory remarks. I think we're ready to go. Mr. Rizzi, would you please call the first item?
Yes, Madam Chair. The first item is case number V-11575-20-UP-1. It is a use permit request by Jason Gonzalez and Amy Kuntz, the owners, to permit a rear setback of 0.5 feet to the accessory structure, outdoor fireplace oven, from the rear lot line instead of 25 feet to the accessory structure as required, regarding after-the-fact approval for an accessory structure in the R10 zoning district on the premise known as 4112 North Randolph Street. Staff recommends the board adopt the attached proposed resolution denying the use permit request. An alternative resolution and conditions have been provided should the BZA see fit to approve the request as advertised. I'd like you to please note there is supplemental material for this case that came in after the application packet was assembled and printed, and we do have an additional speaker on this item as well.
All right, thank you, Mr. Rizzi. Board members, are there any questions for staff at this time? Okay. I guess we're ready to hear from the applicant. Is Mr. Gonzalez or Ms. Kuntz here tonight?
Yes, we are. Can you hear us?
We can hear you. We don't see you yet.
Oh, the camera's on. Maybe it'll.
It'll take a minute. Sometimes it just takes a minute.
Okay. Well, we know you have a really full agenda, so maybe we can start just by the oral presentation. So I'll just begin by saying, Chair Malice, Vice Chair Owen, that we are grateful to be back before you to discuss this application. Mr. Rizzi has a photograph of a proposal that we'd like to discuss with you, so maybe he could put that up on the screen. Yeah, that's the one. So as you might recall, the BZA deferred this application from the November hearing for the purpose of proposing a fence design at the time and to allow additional communication between us and the rear neighbor. We understand that you have a lot to review tonight, so our goal here is going to be succinct, to try and be succinct and give you the information you need to make a final decision on this project. I want to be upfront and say that we were not able to reach a joint proposal with the rear neighbor despite our best efforts. It was certainly our intention to come back to the BZA with a proposal that the rear neighbor favored, and as I'll explain in a moment, we offered numerous concessions to the neighbor, all of which are documented in your supplemental materials. We gave the neighbor 4 proposals. I'm going to walk through them, the timeline pretty quickly because I think the details will be instructive to your decision. We initially approached them just after the November hearing, and they refused at the outset to even discuss the proposal with us. On our second try, though, we were successful in getting them to look at 2 alternative fence designs. Both of those designs consisted of just raising a section of our fence from 5 feet to 6 feet so that it would be above the height of the fireplace. The fireplace is 5 foot 8 inches high. The designs were contoured or curved so that this new section could match the remaining part of our existing fence. Our objective was just to replace the parts of our fence that posed a problem. The rear neighbor rejected this proposal, demanding a solid privacy fence at the maximum height under the code, which is feet. We didn't see any reason to be difficult about this. So we changed the 2 fence designs to include a solid fence that was 7 feet high. The plans indicated that a 12-foot section of the fence would now be made solid and we would tie into our existing fence line along the rear line. That was always our intention. When they eventually listened to what we had to say, they agreed and sent us an email stating that the 4th design choice was acceptable. They also asked us if we could align the peak of the fence with the height, the top of the oven. If we could briefly draw your attention to the photo on Mr. Rizzi's screen. The photo shows that there is 4 panels there, each 6 feet wide across. In short, the design calls for the 2 center panels, which would be 12 feet maximum, to be raised to the maximum height of 7 feet. And then there'd be 2 more panels that would curve downwards into the remaining fence. So finally, on the 7th of November, we gave the rear neighbor the drawing you're looking at now and said that we would like to submit this with their consent to the BZA for review, and indicated our willingness to discuss the most recent demand concerning the peak of the fence with our contractor. At that point, we were ready to proceed and come to you with this proposal. Would be a joint proposal, but to our disbelief, the neighbor replied and told us that he was no longer in favor of the 12-foot wide privacy fence we thought we had agreed to. As I understand it, a solid 90-foot wide long fence along the entire lot line is now the only option he supports. Of course, we're sad and dispirited by the news. We went back just to make sure that we didn't miss a step and listened very carefully to the guidance that the BZA members gave us during the last September hearing. The neighbor's current position, we believe, is more stringent than what was discussed during the prior hearing. Indeed, there were comments in the record from a couple of BZA members expressing doubt about the need for a 7-foot fence across the entire rear lot line. We understand that the BZA has total discretion to impose conditions in connection with this permit, but respectfully, we think that requiring basically a solid wall that's 95 feet long at the maximum height under the code is an unreasonable demand. A fence that size doesn't do anything more than the 12-foot privacy fence we're suggesting to alleviate the neighbor's stated concern about being able to see the fireplace, to say nothing of the absurdity of the cost that would impose on us. To put this into perspective, again, our fireplace is about 6 feet wide. The fence we're proposing would cover a size twice that size. The neighbor's proposal would require coverage 16 times greater than the size of the fireplace. We are not here to waste the board members' time arguing about concepts or suppositions that aren't grounded in facts. We made numerous pleas to that end for the neighbor to give us photographs from his yard because we thought it actually might help you consider what he was asking for. We even offered to take these pictures ourselves, but the neighbor didn't so much as acknowledge those requests. We have a second photograph that we just like to draw your attention to. If Mr. Rissi would be so kind as to change the picture, there it is. On the screen in front of you and in your materials, there's a simple panoramic view of the whole yard that shows the coverage already provided by the numerous trees and bushes existing along the rear line, and thus the lack of any meaningful benefit that would result from the construction of a 95-foot fence. There appears to be no justification in our view for this request. In fact, it feels to us, sadly, like an attempt to leverage the hearing and the BZA to get a new fence. This seems like an inappropriate use of the BZA. I want to say before I end that we are ready for this long and difficult process to come to an end. The whole experience has been very taxing on our family. Our children have had a lot of anxiety and sadness about the possibility of losing this fireplace. And we just, in fairness to them, don't think it would be fair to proceed any longer. In closing, I want to respectfully say that the BZA should adopt the resolution we're proposing that would grant the use permit in the design that we just showed you. There is a sample resolution in the materials we've provided. In fact, if you look at the language we're proposing for the resolution, it gives us the flexibility in the future to extend the privacy fence beyond a much wider area along the rear lot line. But obviously, we would be under no obligation to do that right now in connection with this permit. In the alternative,
Mr. Gonzalez, I'm sorry, your time has, you've exceeded your time.
Okay, I was done, so we'll answer any questions. Thank
Okay,
you.
thank you, and thank you for all the material that you provided. Mr. Rissi, we have another speaker.
Madam Chair,
Who is that, Mr. Owen?
yes, just for
Yes.
the record, I note that Ms. Clark appears to have joined us.
Thank you. Mr. Rissi, we have another speaker. Mr. Schneider is here with us. Mr. Schneider, would you like to speak?
Yes.
You may proceed.
Hello, can you hear me?
Not very well.
Okay. At the September 30th BZA meeting, there's a discussion that a long fence would be built upon on the common property line in lieu of removing the structure, and this was the burden of the applicants. And during the meeting, this was referred to as a long fence built between your properties and a long fence based on the tax maps. It was not discussed as a partial fence or a panel or a partial screen. That was the understanding that I had. We could not come to an agreement on a fence that would span the length of our properties, although I had requested a 7-foot high fence along our common 80-foot lot line, but no proposal in this regard was ever tendered by the owners. The first proposal that they sent, I thought, was a fence going along the lot lines, which is why I was in agreement, but found out later that it.
Mr. Schneider, are you there?
No, I
Yeah,
think
okay, I got muted. So a fence along the common property line was never discussed, despite bringing it up 3 times in writing. It was only rejected. The current unaccepted proposal by the owners that consists of a 12-foot wide panel with side panels of indeterminate width would, from my yard, have an open picket fence of about 17 feet on one side and 39 feet on the other side, which would look very strange. This configuration, the current configuration that's proposed, rather than negating the effects of the structure in the pizza oven, will instead accentuate and enhance the structure, making what was termed in the last meeting an obnoxious location at the worst possible location. That's not my words. Even more obnoxious. It's as if a 6-foot wide, 5'9" high structure has now become a 24-foot wide by 7-foot high structure or panel at its peak, which I feel would affect the value of my house. I was asked in the meeting if a fence would be better, worse, or no change.
It was on 100 when I came in.
Mr. Schneider, you've exceeded your time period.
I've one more sentence and then my request, and then I'll be done. But if the proposed configuration had been offered at that meeting, I would have said it was worse. So I'm asking the panels to accept the initial recommendation of the zoning division, and that is to find the structures in violation. Thank you.
Thank you, Mr. Schneider. Any questions for the applicants, colleagues? Applicant or speaker?
Madam Chair,
Mr. Owen?
I just want to thank both the applicants and the neighbor for continuing to try to engage on this. While it's disappointing that there didn't seem to be common ground, I appreciate that both the applicants and the neighbor stayed engaged to try to explore if that was the case. I just want to express that.
Thank you for that. Appreciate it.
Any other questions for the applicant or the neighbor? All right, the discussions with the board.
Madam Chair,
Who's that, Mr. Melnick?
Yeah, but I'll defer to Mr. Owen. They'll go second.
Oh, okay.
I was going to make a motion, so if you want to ask a question or make a comment, you should go first, Mr. Melman.
Mr. Melnick, go ahead.
All right. The way I look at this, and I'm sympathetic, to people who build things and they're not aware of the rule, but we are, we're bound to follow the ordinances, and basically, were to look at this, whether it permits compatibility of development with surrounding neighborhood, that the size and placement are similar to structures of the property surrounding the subject property. And clearly the staff report, the closest thing was a wooden shed at 2.7 feet, nearly 3 feet. And this is like a half foot. So it just looks like under the requirements that we're bound to follow, it just doesn't look like, by preponderance of the evidence, this has been shown to meet the requirement. And so I'm not going to support this just because of that. And so, but I do sympathize, with the cost it would take to move it. But I think, we just have to follow the rule as far as that goes. So that's my comment.
Madam Chair, could I just address Mr. Melton's concern?
I'm sorry, the discussion now is with the board. I'm not sure who was speaking. Is that Mr. Gonzalez?
Yeah, I just wanted to.
Mr. Gonzalez, we really are past taking further testimony. But I'll grant you 15 seconds if you have a quick point you want to make, but we really don't want to debate each other here.
I appreciate that. No debate. The only comment I'll make in response to Mr. Melnick is that, look, if the board finds in its wisdom that a solid fence along the rear line is acceptable, obviously, like I said, we would do that. The hardship of destroying this pizza oven that the kids love is just too much, I think, for our family to bear at this point. So we would just ask you to respectfully take that into account. I know these are tough judgments you have to make, but that's all.
Thank you for that clarification, Mr. Gonzalez. Ms. Freshman?
Yes, I understand the complexities of this issue, but I agree with Mr. Melnick. This is something that was built in the wrong place and much too close to what's permitted. I understand the dialogue about a fence, but this is all just trying to figure out how to make something that shouldn't be there acceptable. And I'm sorry that there's conflict between neighbors, but I can't support it either.
Not even with a 7-foot fence across the entire lot line?
Mr. Gonzalez.
I'm sorry. Yeah.
We heard you.
Yeah.
Okay.
Madam Chair,
Mr. Owen?
I'm in agreement with my colleagues. The question before us is whether or not to approve this structure. And sometimes through discussions between neighbors, a solution emerges that everyone agrees is superior to the options that would ordinarily be presented to the board. But that's not our primary mission. Our primary mission is to resolve the application before us. It is staff recommendation for denial. To be honest, even if there were a fence built, I'm not sure the criteria would still be met, as Mr. Melnick pointed out. In fact, there is not and so the agreement of neighbors is not the issue. The issue is our assessment as the BZA as to whether or not the proposal overall meets the terms. And so it's speculative whether or not any other application besides this one would meet the terms, but this one certainly does not. And that includes the option for Exhibit A. That includes the option with no change in fence. I don't know what other fence options there would be, but we've studied that for a month and nothing came up. So I think it's appropriate now for us to act on the application before us. And I agree with my colleagues about the proposed disposition. Accordingly, I move that the Board of Zoning Appeals approve the attached proposed resolution denying the use permit V-11575-20-UP1 subject to the conditions listed with an additional whereas clause, whereas a new final whereas clause, whereas the BZA finds that the proposal would be injurious to properties or improvements in the neighborhood.
Second.
Any further discussion? Miss,
I just want to once again commend the applicants, especially for their efforts over the last month. I'm sorry that it didn't work out, but I wouldn't want them to feel like this was about a fence. It's about the oven and the location of the oven. And the fence was a Hail Mary pass to see if something could be worked out. And sometimes they don't work out. And that's just the way things work here at the BZA sometimes.
I think we're ready for a vote. I will call the roll. Mr. Owen?
Aye.
Ms. Freshman?
Aye.
Mr. Melnick?
Aye.
Ms. Clark?
Aye.
Chair votes aye. The motion fails. The motion to deny is passes 5-0. Again, I appreciate all the effort that everyone put into it, and regrettably, we need to just move forward. Mr. Rizzi, would you call the next item, please?
Yeah, the next item is case number V-11571-20-UP-3. It is a use permit request by the Bangladesh Islamic Center, the owner, to permit the following setbacks from an existing non-residential religious institution structure: 13.4 feet to the wall from the center line of South Nelson Street, 15.4 feet to the wall from the street instead of 50 feet is required to the center line, 25 feet to the street, 5 feet to the wall, 4.6 feet to the eaves from the right side lot line instead of 20 feet, 16 feet to the eaves as required, and 2.6 feet to the porch from the rear lot line instead of 50 feet as required, to permit the following setbacks to an accessory residential dwelling: 20.8 feet to the wall, 19.5 feet to the eaves, 17.1 feet from the existing stoop from the front South Nelson Street instead of 25 feet to the wall, 21 feet to the eaves and stoop as required, and a rear setback of 0.1 feet and 0.6 feet to existing detached accessory building shed instead of 1 foot to the eaves as required, regarding the dedication of a property for street purposes necessary for the combination of 3 existing lots with existing structures to create 1 single lot from the properties known as 2116, 2122, and 2130 South Nelson Street. Staff recommends that the board adopt the attached proposed resolution, partially approving and partially denying the use permit request with conditions. An alternative proposed resolution has been provided should the BZA see fit to approve the case as advertised. And I'd like to please note that there is supplemental material for this case that came in after the application packet was assembled and printed.
Madam Chair?
Mr. Owen?
2 things. One, I just want to note that I am acquainted with several of the individuals in the neighborhood who have written to us, and I presume who may testify. But I do not think that my association with them is so close as to require my recusal from this matter. And the second thing is, I just wonder if Mr. Rissy could describe the supplemental material.
We have letters from surrounding neighbors with their concerns about the current situation. There's also supplemental material from the applicants, including additional support and a revised disclosure statement.
Thank you, Mr. Rissy. Ms. Clark?
Madam Chair, I just wanted to note that I am going to recuse myself from this matter, being president of the Green Valley Civic Association, and that several of the residents have been reaching out to me, and I've been affiliated with this issue for quite a while.
All right. Thank you, Ms. Clark. Any questions for staff?
Madam Chair? Just as an introduction to my questions, I would like to note that this kind of application is relatively rare for the BZA. So I think one of the challenges that we face as a board is to make sure that we're understanding our proper role in this discussion. Some of the issues that are brought up on this case would be more naturally handled by the county board or by others. And I'll speak to that more later. But I don't want anyone to get nervous by the fact that I'm asking these questions, that necessarily the BZA, that I or the BZA is going to veer off outside of its jurisdiction. I just want to understand more about the context in which we're operating so that we properly follow the piece of this that is our proper role. So with that, my first set of questions is related to the consolidation of the 3 residential lots. Is the consolidation by right, or does some county entity need to grant permission for the consolidation?
So a consolidation is actually a form of a subdivision, and all subdivisions do have to be approved by DES, which is the Department of Environmental Services.
So it's a staff level approval based on set criteria.
Consolidation is yes, staff level approval.
Has the lot already been consolidated, or is that action pending?
That action is pending.
What happens to the consolidation if the BZA were to vote against this use permit application?
My understanding is they would not be able to consolidate the lots, or they would have to modify the existing structures such that they met the ordinance's requirements.
So we're not legally ruling on the consolidation, but practically we are, unless they want to rebuild the buildings.
I would say that is a fair assessment.
Okay. The applicant has indicated that a key rationale for this use permit application is to allow parking at 2130 South Nelson Street for users of the mosque at 2116 South Nelson Street. However, no plans were provided, at least initially in our packet, for the proposed parking lot at 2130 South Nelson Street. Has the new parking lot been designed?
I would say that the applicant has submitted some parking lot designs in the supplemental material available for this meeting.
Okay. How many cars will be allowed to park in the proposed lot?
I actually don't know that I can answer that question at this time.
What is the required minimum parking for the mosque and residents in the consolidated lot?
So the parking is dependent on the size of the structure, and that's really all I know about it at this point.
I think it might be based on the number of seats in the sanctuary.
Typically with a religious institution, it is based on the number of seats. However, this particular religious institution doesn't have seats per se, so I think they have to give an equivalency for that.
Okay. Will the new parking lot have to be configured according to the requirements of Arlington County Zoning Ordinance 14.3.3C through F, 14.3.3 I, and 14.3.4?
I'm just going to go ahead and say yes. Any parking lot that they try to build here will have to meet the ordinance's requirements for parking lots in 14.3.
Okay. The reason I named the specific sections is that 14.3 itself says things like, except if it's a church, except if it's a residential lot, and so forth. So I appreciate your basic answer. That's helpful. And for those listening at home, those sections basically refer to things like how you build the ramps and the curbs and the how wide the lanes have to be and how the individual spaces have to be marked and all the sort of things that make parking lots seem standard from grocery store to grocery store or church to church around here. Will the new parking lot design be by right? If this lot is consolidated after we've approved, will other approvals be needed for the parking lot design, or will they be allowed to build it by right?
I mean, that's really up to the applicants and what they want to design. They can certainly design a parking lot that can be built by right, or they could ask for some modifications to the requirements. My understanding is any modifications to the parking requirements, though, would have to go to the county board.
If they want to modify the number of spaces, but below what's required.
Correct.
They would have to go to the county board. Okay. The advertised use permit application includes a request for a rear yard setback of 0.1 and 0.6 feet for existing accessory sheds, but in the existing conditions section of the staff report, only one shed with 0.1 foot setback is discussed. Where is the existing shed with the 0.6 foot setback?
The shed with the 0.6 foot setback, I believe, is behind the accessory residential structure.
Is it in the central lot of
Yeah,
the
kind of in
place?
the center of it.
I have other questions, but I'll hold them. Thank you.
Colleagues, any other questions for staff? Mr. Owen, thank you for that list, because I think that is a problem, a challenge that we have is in clarifying what we can and can't do. But I do have a few more questions. Mr. Rissy, do you know if the number of parking spaces required by the ordinance for this use can be built by right?
I do not.
Okay, so we don't know whether in order to satisfy the requirement, they must go to the board.
Correct.
Okay. Does this mosque operate under another use permit that was granted by the county board?
I actually don't know the answer to that question, but I'm guessing our applicants do.
Okay, well, we can ask that. I think one of the things that maybe Mr. Owen was getting at, and one of the questions I have is that, you know, there's a number of issues in the community on this site that the community would like to have addressed. And I'm trying to decide trying to understand if there's a forum other than us where these issues can be aired, and at what opportunity. So the extent to which things happen by right would suggest that there is no other forum for neighbors to bring their concerns. If there is an existing use permit that covers the operation of this, that those use permits are reviewed periodically by the county board, and the county board would be the forum to which they would take their concerns. All right, I appreciate your answers. I appreciate your questions, Mr. Owen. Any other questions for staff before we hear from the applicant? All right, Mr. Rissy, is it Mr. Lawson that is here for the applicant?
I am. Can you hear me?
Yes.
Oh, good. Should I go ahead and start, Madam Chairman?
Yes, please.
Okay. Staff is recommending approval of the setback relief for the front of the structures. They're not asking, or they're not recommending approval of the setbacks from the rear. There are two sheds and they are going to be removed. And we have a sketch that we did showing how a parking lot could be laid out, and we will move it to a place where it does not require setback relief. The porch that is described, and I sent some pictures, is really a covering of an area behind the mosque. There's a patio in the back, and there's a cover over it. And after services, the members go there and they have fellowship and sometimes share drinks, non-alcoholic, and food. If you all are inclined to grant that relief for the rear porch, we have offered to raise the fence that's between us and the property behind us by 1 foot to 7 feet in height, which would do a good job of screening it. We spent a whole lot of time and effort reaching out to neighbors and the Civic Association. And we have proposed conditions that you all can impose should you be inclined to grant this. These are things that Mr. Reese thought could be enforced by the powers that be in Arlington County. For the ones he did not think could be enforced, we wrote up an agreement with the Civic Association that we would be willing to enter into. As you go down the list of things that we're willing to do, and this is now in the agreement that we're proposing. We're proposing shielding the light for our fixtures. We have security fixtures. We'll put new ones in the parking lot. That's very common in Fairfax, that you shield your light in such a manner it doesn't impact neighboring properties. Paragraphs 3, 4, and 5, we have done those also in Fairfax, where we have a pastor or the leader of the worship will remind the attendees, please don't do whatever. And we've listed the things that we've heard as being a concern. In paragraph 6, we've agreed that we would hire a security guard if that was needed, again, to help monitor what's going on out in the out on North Nelson Street. This is commonly done out in Fairfax. I want to share that the mosque also has some rights, and we've tried very hard to accommodate neighbors' concerns. But the county board in Arlington allows houses of worship by right. And that's the situation here. This has been existing by right. Now, the usual church that gets approved, and I've done them in Fairfax where they do need use permits, your typical worship is Sunday, maybe for 3 or 4 hours. You might have Wednesday Bible study, something of that nature. You have Sunday school. You might have some weekly meetings, things like that. This worship is very different. It takes place several times during the day and during the week. And so this has a greater impact, and that's why we've offered up to do these conditions. The mosque desperately needs the parking, and what they need is not this gravel area, but they need a properly designed and built parking lot to accommodate those that come there to worship. I would respectfully submit that assuming we didn't offer any conditions to the community would still be better off. Now, I want to address the big concern that I've heard over and over and over, and that is, well, if this parking lot gets built, then you're just going to expand. And I don't think that's going to happen for 2 reasons. One reason is that the building can only accommodate so many people. And I took a picture during one of the worship services. I don't know if you all can see it. I'll try to hold it up. There's a little bit of area behind where these folks are, because that's where I was placed. But you just can't have that many more people. And then the second thing is there's a very narrow by right building area that the church, that the mosque could expand into. And if they went to the side, they would encounter a cliff. So I think that concern is just not, is misplaced. Thank you. I'll be happy to answer questions.
It appears that we have no speakers here in person, though we have received testimony in writing. So if colleagues, if you have questions for Mr. Lawson, I think this would be the time to ask.
Madam Chair?
Mr. Melnick.
Yes, so Mr. Lawson, so you were saying, I saw the arguments about the fear of the mosque, the attendees expanding. And then there was some talk about attendees, if I read it right, actually being outside, worshiping, like whether on the sidewalk or the yard, but actually coming out into the public areas. Did you address that?
I'm sorry, that's after the service. Gosh, in the Methodist church I grew up in, after the service, you go down to the basement and have some fellowship for a few minutes, drink some Cokes and so forth. That's what's done here out on the outside patio. They don't really worship per se there. And I attended several services just so I could speak intelligently about this.
Okay, thank you.
Thank you, Mr. Mr. Owen, are you reaching for your mute button?
Yeah, Mr. Lawson, do you have a notion of what the required minimum parking is for the consolidated site?
Well, I'm not sure. Steve and I have discussed this, and we probably need some kind of a determination administrator. The ordinance says, and it lists mosque, and then it says there shall be one space per 5 seats. And as I showed you, there aren't seats. And so you've got to do one of two things. You've got to do it by people, or you got to do it by area. And I think the bottom line, Mr. Owen, is right now there's no parking. And so any parking we add is going to help. Whether we get it up to what code would require, I don't know without going through the exercise with the zoning administrator. But I think any parking we add is going to help cure the situation.
Thank you, Mr. Lawson. I'm sorry.
I'm sorry.
I had a question.
Go ahead.
Mr. Lawson, as we saw with the last case, and as you're well familiar with, when we consider use permits for encroachments on side and rear yards or street encroachments, we typically have a design for the whole structure. So even if someone's adding a porch in back or an addition on the side, we usually ask for and receive plans for the complete site, basically. And sometimes working out a encroachment that makes sense for the neighborhood involves modifications or conditions that affect more than just the specific constitutes the encroachment, as you know from your experience with us. Since so much of the purpose and rationale of this whole exercise relates to on-site parking, I'm wondering why it doesn't make sense for us to incorporate a parking lot design into this use permit approval, just like we would approve a total design for many other structures when we were talking about an encroachment. Can you speak to that?
Yes, let me give you an answer that may not totally satisfy you, but I'll share my answer with you. In order to do a design that we could be bound to, we would have to have more engineering done. And which comes first, the cart, the horse. And so, we wanted to get the approval before we do that final engineering. Also, there's going to be fundraising done by the membership of the mosque. And we have 2 potential layouts that Hamid did. And one is it's going to depend upon how much money they're able to raise as to how many spaces they can add. And if they go to the ultimate, it'll necessitate the raising of the house. So they've got to, look at that. Mr. Owen, would it be acceptable to do something maybe a little out of the ordinary? Would it be acceptable for us to come back to you when we do have a final design of the parking lot, give notice to the neighbors, give notice to the Civic Association, and let them comment on the final design? Does that sound like perhaps a reasonable compromise?
Speaking for myself, Mr. Lawson, I think that's an interesting idea, but a very complicated one.
Yeah, but I think before we commit to any notions of how we move forward, let's hear from everybody as to what their issues are. Ms. Freshman?
Yeah, I appreciate, Barnes, your explanation of this application, and particularly that it is a by right use, and that and the differences between churches and synagogues, which, as you know, typically have
Awesome.
a limited use as compared with the mosque, and because it without knowing the exact details, but you said they meet on multiple days and multiple times per day. One question I have is, do they meet at night? And if that would require lights, which might cause, even if shaded, might cause further disturbance in the neighborhood. And the frequency of the use and the number of parking spaces, I presume, could be calculated by whatever the capacity is of the structure itself. People versus seats, I don't think, would be different. But my concern, because so many of the neighbors had written to be concerned as much about traffic as the actual parking, the frequency of the services and the people coming and going, multiple times throughout the day and perhaps at night, is really a concern for the neighbors, and I share that concern.
Yes, ma'am, and we've tried to address that through conditions that Mr. Reese thinks are inappropriate for the BZA to impose, but we have offered up some mitigation measures to the community.
Well, I just one more thing. When you talked about a plan for the parking, that might be a desirable thing to see the actual plan and capacity, but I would not say that's an after the fact issue. If that is in fact what my colleagues would consider to be desirable, it would need to be part of this approval and not something that would happen later.
Is Mr. Mateen, is Hamed Mateen, is he with us?
Yes, I'm here.
This is our engineer. Hamid, how hard would it be?
Could you identify yourself for the record?
Yes, Madam Chairman. My name is Hamid Matin. I'm the engineer for this project.
Thank you. Go ahead.
How hard, how difficult, and how long would it take you, Hamid, to do a design that we could commit to?
We can come up with a site layout that can be distributed and zoning can review it, but to get the final engineering, including the stormwater management, and that would take some time, at least a month or so, to get all the details worked out.
And could the design be altered once it hit, was it DEM?
Yes.
Ms. Freshman, do you have your hand up again, or this is okay? Thank you.
DES, I'm sorry, in Arlington's DES.
Right, DES.
Mr. Lawson, I'm a little confused. I have photographs. I have a photograph in the supplemental material that shows this lot being used for parking today. Is that not correct, that it's already being used for parking?
I think it is used, yes, ma'am.
So would the potential design increase the capacity or be just sort of codify the number of spaces that are already being used here?
I think it would increase.
Okay.
Is that right, Hamid?
Yes, it will increase it. That we will be the orientation will change. A lot of the area is not being utilized right now for the parking, and we will be able to use the majority of the parcel for the parking spaces. Let me go back and answer some of the questions. There was a question about how the seating versus the way the mosque is praying, where we don't have any seating. For the mosque, we normally provide about 6 square foot per person in the prayer hall. That is actually a little bit larger than providing seating. So the number of people that can occupy the space is much smaller if you had seatings in there. So by the sketches that we have done so far, we can accommodate about 140 people, provide enough parking to accommodate about 140 people. But right now it is not.
I'm on your phone.
Hamid, with the sketches that you did, would the final design be close to those?
Very close to those sketches, yes.
But we can't do final, we can't guarantee it because it hasn't been engineered and it hasn't gone through the review process. Could we say it would be substantially similar to one of those two layouts?
It would be substantially similar to those two layouts, yes.
So I think we're making progress. But Mr. Barnes, the first thing you need is a determination from the zoning administrator as to what is the capacity of the mosque.
Well, this is a grandfathered, already existing mosque. So it's not like we're building new. If we were building new, then we have to come to code. Here, we're not to code, so we're adding parking. My guess is that we're going to have more parking than we need, but we haven't gone through that exercise.
So in order to establish what the by right parking requirement is, you do need to know what the capacity is, correct?
I'm not sure about that.
May I answer that, Madam Chairman?
Certainly.
The number of because the size of the building and the area they have available to them for the prayer hall, the number of parkings that at minimum, even the minimum number of parkings that we provide will be around 28, 29 spaces, and that accommodate about 140 people. That is much greater, that even after they expand the building, that's much greater that number of people that will be attending at any one time.
I didn't follow the comment. Is there a plan to expand the size of the building?
No, ma'am.
No.
Okay.
I'm saying if they decide to expand the building, even they will not reach that 140 people with the size of the building it is.
Okay, so I guess it's a question for Mr. Rizzi. Do you believe that a determination is required someplace along the line to settle the capacity question? Oh, you're muted.
Madam Chair, I don't know that I can answer that. Honestly, I don't know. It sounds like Barnes has an idea that a determination may not be needed, and I don't know that I can dispute that.
Okay. All right. So do we have all the issues out on the table, or is there anything else that we need to chew on before we move?
Yes. May I speak?
Who is that?
My name is Ulysses Terry. I'm one of the residents.
Okay. Yes, we had asked, you had not signed up in advance. So let me ask right now, are there any other people here that wish to speak on this that didn't sign up? Okay, it sounds like it's just you, and we will accept your comments. If you could identify yourself.
My name is Ulysses Terry.
You've got that, Mr. Rissy?
Yes, ma'am.
Okay. Go ahead, please.
2-minute speaker.
2-minute speaker, are you, as an individual, correct?
Yes.
Okay, go ahead.
All right. My issue is with the parking lot across the street from where we live. It will first lower our property value of this house. Secondly, with the parking lot that's there, people still block our driveways. The other issue is the prayers that they have all during the day it is true, some people do pray in the backyard of the house and on the sidewalk in front of the mosque.
Okay.
Fridays being the very worst day of the whole week. It's very hard to get down the street because it's double parked.
7 days a week.
Okay.
That's what I wanted to speak on.
All right. Thank you for speaking up.
You're welcome.
Thank you. So beyond the issues of parking lot design, and parking lot capacity, then Mr. Lawson also mentioned a series of agreements that he believed could not go into conditions of the use permit, of this use permit, but could be made separately with the Civic Association. Mr. Lawson, have you gotten any feedback from the Civic Association on that agreement?
I've learned not to speak for other people, so I would let Portia answer that.
Well, Portia's recusing herself from this matter, so I don't know.
Can she participate as president of the Civic Association?
We did receive a letter in the record in the supplemental materials from a representative of the Civic Association.
Are you familiar with that, Mr. Lawson?
I believe so.
It was from Dr. Taylor.
Is Dr. Taylor here tonight?
Yes, I have read that.
All right, I'm reading that the gist of this is that they may have seen your letter of agreement, but are concerned about the non-binding nature of it, not to put words in their mouth.
Yeah, what I did subsequent to the first draft is I added an attorney's fees provision, and in the event there should be litigation, then the substantially prevailing side would be reimbursed their attorney's fees. I don't know really what else I can do to satisfy the Civic Association. We could state it for the record, but if the BZA can't or won't impose them, then we got to have an agreement or something.
So I feel like we're kind of in a catch-22. If the parking is by right, there is no subsequent review or reconsideration. It's only if in terms of whether conditions are, whether agreements or conditions have improved. Agreements are met or conditions have been improved. So I'm not sure how to help the neighborhood feel secure. I see Miss Freshman has her hand up and Mr. Owen has his hand up. So let's hear from them. Miss Freshman.
Yes, I wanted to ask Mr. Rissy, having listened to this debate and hearing the concerns about the parking lot, can you explain the proposed resolution recommendation, which is approval for front and side setbacks only? Can you explain what that actually means and whether or not it has any relation to this discussion about parking? Because frankly, it confuses me.
Yes, Ms. Freshman, the staff recommendation for the approval of the front and side setbacks really does not have to do with the current discussion about parking. Okay. It is entirely for the existing structures which exist on the site, which need their relief through this use permit request. And we just looked at what the applicants had asked for, which is relief from the current structures, and we gave it the same analysis we give other applications.
Thank you. That was where I was leading, but I just wanted to make sure that I understood because parking seems to have taken over the application when it didn't appear to really be part of the basis for it. Thank you.
Mr. Owen?
Thank you, Madam Chair. So I wanted to address, I think in my mind, a challenge we have, which is that it seems to me, based on the written materials we received, that a huge part of the neighborhood's interest here has to do with the behavior of people who have left the site or who are headed toward the site. And there's less of the articulated neighbor concerns for what actually occurs on the site. And in terms of the BZA's authority, you know, where I'm leading is, I think the curb is the limit, the outer limit of what the BZA should be concerned with. I'm very sympathetic to the neighbors' concerns about double parking, parking in driveways, other disorderly behavior in the street, but I don't think that that's a BZA issue. I don't think any of those things that occur in the street are for the BZA to intervene in. I'm less sure, I still have some uncertainty of some things within the curb line, but I feel pretty solid on the idea that past the curb, it's none of our business. And I will just add, because we're a strong community here in Arlington that tries to support each other, and I'll be very brief about this. I think this is a flaw with Arlington County's governmental structure. If these people lived in DC, they would call the mayor they elect and say, hey, mayor, we need some more enforcement of double parking, parking in driveways. We need to get some tow trucks in here and enforce this better. And if the mayor wasn't responsive, they could try and elect a different mayor. If they lived in Louisa County, Virginia, they would elect the sheriff, and they could call the sheriff they elected and say, you bring in the tow trucks and enforce the parking and enforce the disorderly behavior. But here in Arlington, we don't elect the executive branch. That's the appointed county manager and the appointed police chief. And citizens have no direct line to ask for enforcement like most other Americans do for this kind of thing. And that's just an unfortunate flaw of our system of government. So, you know, the next best thing is probably the county board. And so I think for the getting better enforcement of parking misconduct and pedestrian misconduct in the street, that's a matter for a different governmental body than for us. So I just want to put that in one box there. I think it's clear that better enforcement, and I'll also add, it just so happens that the county is undergoing a once every half generation review of its zone parking program. And this seems like the kind of situation that very well might be appropriate for the county board to include in its revision of zone parking. And I certainly hope that the Green Valley Civic Association and its members are participating vigorously with the county board and others in that review, because that might be another way to provide relief for them. But I would just say, Madam Chair, that I think that our conversation is going to be complicated enough, trying to wrestle with the appropriate bounds of our concern about parking within the curb line, as to appearance, as to number of parking spaces, as to the impacts and the balance of parking to the, the rest of the structure. Even those, I could see arguments being made that even those things are not part of our business, and certainly staff is making that argument. I think some of it is part of our business, but I think some more exploration is required to find out exactly what the scope of our. I'm not comfortable saying the BZA has no concern about parking, and maybe the other members of the BZA would disagree with me on that. But I think the reason why we're here is because it's a lot consolidation. The reason there's a lot consolidation is in order to address parking concerns. Clearly, even the on-site parking has impacts. I guess the other thing that I would say is we have had other single family homes and some other kind of residential structures where we would have wished to give parking relief. I'm thinking like the tiny home in Clarendon Courthouse, where they had to mow down a gigantic tree to provide a parking space that we didn't think they needed. And it was very clear that the county board did not delegate to us manipulating parking requirements. So that's clearly outside of our to ask for more or less parking than the code would require. But I do think that the county board has very clearly delegated building aesthetics to us. So I think questions of landscaping, of physical appearance, of lighting, of egress points, those are things that we do routinely deal with. And so I feel like at a minimum, the configuration of the parking lot, however many spaces it will need, the configuration of it, the landscaping of it, its relationship to the buildings and other improvements, I feel like that's pretty close to the scope of what's normal for us as a BZA to be concerned with. So that's sort of my Venn diagram of what's sort of in and out in my own mind about what's our business to be concerned about and what's not.
Thank you, Mr. Owen. Other comments?
Madam Chairman, may I just suggest that we can always come back to the board with the final design of the parking as soon as we get that, and that can be a condition of this approval.
I don't think we can approve it conditionally that way. I think we would have to see it before we approve it, or simply let it go.
Madam Chair, I understood. I'm sorry, I couldn't remember his name, but the engineer.
Hamid.
Say again?
Hamid Mateen.
To be proposing a site plan for the parking lot that we could approve and incorporate. That's what I understood him to propose.
I think he was saying
Barnes Law.
he would bring it back later. You know, that there would be a condition that he would bring it back to us later.
Oh, after an approval.
After
Right.
an approval.
No.
I think that's what he was suggesting, and I don't think that that's workable. That really extends the process for everyone here.
Madam Chair,
Mr. Owen.
Could I ask Mr. Lawson, since I have an attorney here, to me it would seem that you would essentially be consenting to have to get another use permit, and that seems ultra virus to all of us. Do you disagree with that?
If we bring it back
to do a 2-round approval, conditioned on approval of I mean, I don't know how we have the power to require another round of approvals. That seems outside the scope of our authority.
Yeah, it's been done in, excuse me, it's been done in Fairfax. And they often approve things and, you know, come back with the final design of whatever. And the planning commission won't, you know, they have to approve something, but they alter the design. That's what Hamid was suggesting, and that's what I was suggesting. I'm not sure that process would work as well in Arlington, but that has been done successfully in Fairfax.
Okay. Go ahead, Madam Chair.
I'm just not sure if that second approval then would still prevent you from moving forward with your plans. I think that's very awkward. Go ahead, Mr. Owen.
No, I can see that there's not sufficient support on the BZA for this 2-step approach. So I think we can probably move on from it.
Mr. Lawson, how much time would you need to come back with a site plan that lays out
Yeah.
What sheds are going to be removed, what happens to the porch, and how you would configure parking, and where minimum egress, points.
When is your meeting in December?
Our meeting in December is quite full.
No, January.
Are you meeting in January?
We are going to meet
Yes.
in January.
Oh, boy, okay. That's
Yeah.
that's new, isn't it?
Yes, it is. Staff indicates that they would welcome that meeting, and we
Well,
would too.
Yeah, it sounds like you all would be much more comfortable with a design you could rely on. And Hamid, I think we should do that for these guys.
Sure.
Would the January meeting be enough time, Hamid, for you to get something, maybe get a quick review by, somebody in the county, at least, say, yes, this looks like something we can approve. Yes, maybe.
That's very much possible. Would the staff want to see the design first and review it?
I think we want to at least know there's not going to be any major changes, so that we could have a condition that the parking lot, when installed, would be substantially similar to your layout.
Yes, we can.
So, Mr. Lawson, I'm sorry, Madam Chair, if I
Go ahead.
So if we're going to do a deferral, I'll just say that I would be interested in looking at some of the conditions that were in your proposed agreement, Mr. Lawson. So
Yes.
obviously the lighting condition, I would want to see further developed and discussed with the community. The liaison condition, I think I would love to see further developed and discussed with the community. Those were the ones that caught my attention.
Yeah, the liaison was taken from your standard site plan conditions. The lighting one I took from a Fairfax proffer, set of Fairfax proffers.
But I would love it if you could try to reach out to the community again, now that they've heard more about what the BZA thinks the scope of its authority is, and really focus in on those and see if there's any further adjustments that they would request.
Yeah, Portia had said she was going to try to gather some folks up and down Nelson, and I think she ran out of time, and maybe it would make sense to do that as well.
Yep. And we're not talking very much about the sanctuary structure, which is the subject of 3 of the setback requests. So I think for the community who might be listening, I hope that they look at that as well, and make sure to put in the record any thoughts they have about those encroachments, because that's really the core of what we're supposed to be reviewing.
Yeah, this whole thing being here before you all was generated by the fact that we're dedicating 5 feet. That's the whole. So no good deed goes unrewarded.
Mr. Lawson, I think we're going to move.
I wrote a good to the little boy, but he never did come back.
I'm sorry, who was that? Mr. Lawson, I think we are going to move to a motion, but I just wanted to follow up on one comment. What would you expect the timing of the improvements to be? You mentioned that there's some fundraising that needs to be done.
Hamid, do you know where the mosque is on that?
I have no idea.
We'll have to
find out, let you know.
Yeah, we'll have to talk to them. But I mean, if nothing else, we could go with 2. We could show, alternate 1, alternate 2, or maybe we could have phase 1, phase 2, and they could add on later. But that's something we'll talk to the mosque about, not to create more detail.
The other thing I would put on the list is there's been some talk about, there's some question about future expansions. And typically, when we issue a use permit approval like this, we freeze the plan. We freeze the site plan. So I'm presuming that any expansion to the main worship structure, if we were to approve this use permit, would require a further use permit from the
That's
BZA.
acceptable. Our by right envelope is something like 20 feet wide, so,
Okay.
and we also hit the cliff, so that would be an acceptable condition.
Okay, I think that would be helpful to make clear to everyone involved.
I think it would, because that's, I mean, talking to many of the neighbors, that's what I heard over and over. You know, if we approve this, is it just going to create, you know, more people, more worshipers, more traffic? And I think we could, with that condition, probably ease the concern.
Thank you very much, everyone. I think this was a helpful discussion. It certainly clarified things for me. Is there a motion?
Okay.
Ms. Freshman?
Yes. In the case of V11571-20-UP-3, I move deferral to January 13, 2021 BZA meeting for the purposes that have been enumerated.
Second.
Seconded by Mr. Owen. We have a motion made by Ms. Freshman, seconded by Mr. Owen to defer to January 13. Is there any further discussion? I will call the roll. Mr. Owen?
Aye.
Ms. Freshman?
Aye.
Mr. Melnick?
Aye.
Ms. Clark has recused herself. Chair votes aye. Motion passes 4-0. And I think Ms. Clark is not present.
Thank you.
I'm still here, Enter.
You're present. You are recusing yourself. Is that an abstention?
Yes.
Okay. Thank you for speaking up, Ms. Clark. I've got more buttons to look at here than, and you're just coming across as the big P. All right. So that motion passes 4-0 with one abstention. We will see you all back in January. Mr. Rissy, will you call the next item?
Yes, the next item is case number V-11588-20-UP-1. It is a use permit request by Bart and Bethany Epstein. The owner is permitted a street setback of 13.2 feet to the porch, 12.2 feet to the porch eve from 22nd Street instead of 21 feet to the porch, 19.5 feet to the porch eve as required regarding a new front porch on a corner lot in the R5 zoning district on the premise known as 738 22nd Street South. Staff recommends the board adopt the attached proposed resolution granting the use permit request with conditions. And I'd like you to please note that there is supplemental material for this case that came in after the application packet was assembled and printed.
Thank you, Mr. Rissy. Any questions for staff?
Madam Chair,
Mr. Owen?
I'd just like to note that I found the supplemental materials from the applicant to be extremely informative and helpful.
Thank you. If there's no questions for staff, let's move on to the applicant. Is Bart or Bethany Epstein with us?
Yes, Madam Chair, we're here with our.
All right, I see you. Good evening.
Good evening, and our 13-year-old sons are watching as well and a lesson in how county government works. So thank you so much for that.
All right, well, we'll keep it clean.
I have nothing to add unless you have questions. I believe that our application and the supplemental materials should provide the information you need to make.
Thank you. Mr. Rissy, I don't believe we have any speakers.
None who signed up in advance, Madam Chair.
Okay, is there anyone here that wishes to speak on this? Okay, Ms. Freshman?
I'd like to commend the applicants for their neighborhood outreach, completely encircling their property, and I'm prepared to make a motion.
All right, Ms. Go ahead, you have the floor.
I move the Board of Zoning Appeals approve the attached proposed resolution approving use permit V-11588-20-UP1, subject to the conditions listed and with the addition of the 3-year time limit.
I'll
Second.
second.
Seconded by Mr. Melnick?
Yes.
Or Mr.
Yes.
Melnick?
Dave,
Melnick.
All right, I think that was a tie.
Okay.
I'll give it to Mr. Melnick.
I'm giving it to Mr. Melnick, okay.
He's got seniority.
All right, any further discussion on this item? I will call the roll. Mr. Owen?
Madam
Oh,
Chair, I do have
yes.
some discussion.
Okay,
Um,
Mr. Starr.
I'd like to note that based on the staff report, I did not feel we had the right information to be able to make our determination about compatibility with the surrounding structures, the structures surrounding the lot in question that the ordinance requires. The applicant in the supplemental material provided measurements of surrounding properties, which in fact are quite similar in their setbacks to what the applicant is proposing. So that evidence is clear. I think this is a clear and easy case based on that evidence. But I just wanted to note that the staff report used properties that were quite far away. All but one of them didn't even appear on the map that we were provided. And one of them in particular was a very unusual approval that we recently issued for an extremely small lot that's surrounded on 3 sides by commercial structures. And I'm concerned that entities within the county might be advising people throughout the neighborhood that now a 2.3-foot setback is acceptable in the neighborhood because of that one approval. I believe that the reason why we did not get the more immediate surrounding information that the applicant gave us from staff was simply that that information is not available to staff easily from where they sit. So I just want to confirm with Mr. Rissy that that you gave us the closest ones that you could find using the research tools you had available. Is that right?
Mr. Owen, I didn't actually write the report for this, so I can't say how the staff member chose the properties that they did, but I think that you're probably right. Some of the properties that the applicant went out and measured with the laser, we probably didn't have plats for in our files.
Okay. I'll just say that I think that that's probably the intent of the county board in delegating to us the use permit authority here. I think the expectation is that when you go to the site and you look around, that people are not going to be building something that looks odd where it is, and not something that would or wouldn't look odd 3 blocks down the road. So, so I think that's a challenge that we face just administratively as a BZA. And I'm very grateful to the applicant for the extra work to make his own case very easy with those extra information. So thank you.
Thank you, Mr. Owen. You know, I too share the concern about the using as a precedent the very small setback that we recently approved, and I don't know how to not sure how how to avoid that, but because we do decide situations case by case. I don't believe we're entirely bound by precedent. We're bound by what we see on the block, more than that. And so I think we do have to be careful of what is used. Now, it is extremely helpful that staff references that it is a BZA action so that we can go back and check ourselves to see what conditions were on the ground when we granted a particular approval. Ms. Freshman, did you want to comment?
No, sorry.
Hands up. All right. So we have a motion on the table made by Ms. Freshman, seconded by Ms. Melnick for approval of this use permit. If there's no further questions, I'll call the roll. Mr. Owen?
Aye.
Ms. Freshman?
Aye.
Mr. Melnick?
Aye.
Ms. Clark?
Aye.
Chair votes aye. Motion to approve is granted on a 5-0 vote. Thank you, Mr. Epstein.
Thank you very much. And that's
All right. All right. Enjoy your project. Mr. Rissy, will you call the next case?
The next item is case number V-11589-20-EP-1. It is a use permit request by Michael Shapiro and Julie Rosenberg, the owners, to permit a rear setback of 15 feet to the deck and rear porch 14 feet to the porch eaves from the rear property line instead of 21 feet to the deck and porch 19.5 feet to the porch eaves as required. To permit a side setback of 9.7 feet to the porch, 5.5 feet to the landing from the right side property line instead of 10 feet to the porch, 6 feet to the landing as required, and to permit an aggregate side yard of 17.6 feet instead of 18 feet as required. Regarding a rear screen porch and deck addition to an existing one-family dwelling in the R5 zoning district on the premise known as 808 North Buchanan Street. Staff recommends the board adopt the attached proposed resolution granting the use permit request with conditions.
Thank you, Mr. Rissy. Any questions for staff? No questions for staff. Is Mr. Shapiro or Ms. Rosenberg here?
This is Michael Shapiro. I'm present.
Hi, good evening.
All right.
Do you have any comments you'd like to make?
No, very briefly. Again, there is an existing deck and stairs leading to our backyard with a shed underneath. What we're proposing to do is replace that existing deck with an enclosed porch. We're going to refurbish the stairs on the same footprint, just putting in more modern durable materials. And we're adding a 5 by 5 foot deck adjacent to the porch to allow a small area for a small barbecue. So overall, the footprint of the structures would not be changed very much, primarily the additional 5 by 5 area and roughly 1 foot eaves on either side of the porch would be the additional area that would be taken up by the proposed structure.
Okay. Thank you. Mr. Rissy, we had no speakers on this item signed up.
None that signed up in advance.
All right. Is there anyone here that wishes to speak on this item that didn't sign up? Okay, doesn't sound like it. Any questions for the applicant?
Madam Chair,
Mr. Melnick?
so I'm prepared to make a motion.
All right.
So in case V1158920EP1, I move that the Arlington County Board of Zoning Appeals adopt the attached proposed resolution granting the use permit request with the conditions as stated, including the 3-year provision as previously discussed.
Yeah, that's right. Is there a second?
Second.
Seconded by Ms. Freshman. Any further discussion? I will call the roll. Mr. Owen?
Aye.
Ms. Freshman?
Aye.
Mr. Melnick? Ms. Clark?
Aye.
Chair votes aye. The use permit is granted on a 5-0 vote.
Thank you.
Mr. Shapiro, you're all set.
Thank you very much.
All right, thank you. Mr. Rissy, will you call the next item?
The next item is case V-11590-20-UP-2. It is a use permit request by Natalie Ulmer, the owner, to permit a side setback of 7.7 feet to the wall from the left side property line instead of 10 feet as required, and 6.3 feet to the wall, 5.2 feet from the eave from the right side property line instead of 10 feet to the wall, 6 feet to the eave as required, to permit an aggregate side yard of 14 feet instead of 18 feet as required, and to permit a street setback of 20.1 feet to the porch instead of 21 feet as required from North Custis Road. Regarding a new area porch 2-story side addition and replacement of non-conforming second-story walls in the R6 zoning district on the premise known as 2500 North Custis Road. Staff recommends the board adopt the attached proposed resolution granting the use permit request with conditions.
Thank you, Mr. Rissy. Any questions for staff? All right. Is Ms. Palmer here?
Yes, I am.
All right. I'm looking for you.
Here I am.
I don't see you yet, but I
Oh,
hear you.
okay. I guess my camera.
I see her.
You see her?
She's
All
on
right.
her way.
Okay. All right, Ms. Palmer, anything you'd like to say on behalf of your application?
Well, I've been at the house since the early 90s. When my significant other passed away, he left the house to me, and I wanted to reorganize and repurpose parts of the house, keeping aging in place in mind. I wanted a eat-in kitchen, and with the pie-shaped lot that I have, some of the setbacks were a little difficult to comply to, so I'm applying for the use permit with those exceptions.
Thank you, Ms. Palmer. Are there any other speakers for this one? I see your architect has appeared. Did you wish to speak, or are you just here for support?
Just in case you have technical questions.
Thank you. Then there's no other speakers, Mr. Rizzi, on your list. And is there anyone here that did not sign up that wishes to speak on this? I don't see anybody. Okay. Any questions for the applicant? All right. That's a good sign. Do we want to move to a motion?
I will.
Ms. Freshman?
Yes, I move the Board of Zoning Appeals approve the attached proposed resolution approving use permit V-11590-20-UP1 subject to the conditions listed with the addition of the 3-year time limit.
I'll second it.
Seconded by Ms. Clark. Any additional discussion by the board? I will call the roll. Mr. Owen?
Aye.
Ms. Freshman?
Aye.
Mr. Melnick?
Aye.
Ms. Clark?
Aye.
Chair votes aye.
Madam Chair,
Sorry?
I just want to thank the applicant for the diligence of her neighborhood outreach.
Yes, thank you. The motion is granted 5-0. You have your use permit.
Thank you so much.
All right, enjoy. All right. Next item, Mr. Rissy.
Madam Chair,
I recognize Mr. Owen.
I just want to note that I have a loose professional acquaintanceship with one of the applicants for this item, but it is not so close a relationship that I feel I need to recuse myself.
Okay, thank you for that, Mr. Owen. Mr. Rissy, would you like to announce the item?
The next item is case number V-11591-20-UP-1. It is a use permit request by Mary B. McCord and Sheldon L. Snook, the owners, to permit a street setback of 15.7 feet to the wall instead of 25 feet as required from North Hudson Street, regarding the inclusion of an existing screen porch in the R5 zoning district on the premise known as 1414 North Hudson Street. Staff recommends that the board adopt the attached proposed resolution approving the use permit request with conditions. And I'd like you to please note there is supplemental material for this case that came in after the application packet was assembled and printed.
I see that. And that is a petition that was signed by a number of neighbors to this site.
Correct.
Any questions for staff? All right. Ms. McCord or Mr. Snook, would you like to make some comments on your application?
We're both present, and our architect, Trip DeFalco, is also present. We are simply seeking to enclose an existing porch with no increase in the footprint. We're happy we have the support of all of our surrounding neighbors who are able to see that porch. And we're happy to answer any questions or let Trip address any other concerns you might have.
Thank you.
Madam Chair,
Mr. Owen?
my understanding is that the part you're meaning to enclose is on the side of the house, but that you still mean for the front porch of the house to remain either screened or unenclosed. Is that right?
That's correct.
Thank you.
Is that the architect speaking?
It is.
Would you just identify yourself for the record?
Sure. Trip DeFalco, AIA.
Thank you. There you are. Thank you. So, Mr. Owen, does that answer your question?
Yes, ma'am.
Do we need any clarification, or do you think the package is sufficient?
I think my question is fully answered. This is not we're not going to face a porch on top of a porch situation in front of the house. So I'm satisfied.
All right. Are there other questions for the applicant? All right, the discussions with the board, are anything we need to chew over, Ms. Freshman?
No, I'm prepared to make a motion.
Okay.
I move the board. Okay, I move the Board of Zoning Appeals adopt the attached proposed resolution approving use permit V-11591-20-UP1, subject to the conditions listed in the proposed resolution with the addition of a 3-year limit.
I'll second it.
There's only one condition. So this would be condition number 2. All right. Seconded by Ms. Clark. Any further discussion? I will call the roll. Mr. Owen?
Aye.
Ms. Freshman?
Aye.
Mr. Melnick?
Aye.
Ms. Clark?
Aye.
Chair votes aye. The use permit is granted on a 5-0 vote. You're all set.
Thank you.
All right. Thank you for your efforts. Mr. Rissy, would you call the next item?
Yes, the next item is case number V-11592-20-UP-2. It is a use permit request by Andrew J. Monaco and Patrick N. Forrest, the owners, to permit the following: a right side setback of 7.3 feet to the addition wall instead of 10 feet as required, a left side setback of 7.1 feet to the addition wall, 5.9 feet to the eave instead of 10 feet to the wall, 6 feet to the eave as required, an aggregate side setback of 11 feet instead of 18 feet as required, a rear setback of 21.7 feet to the addition wall, 19.7 feet to the eave instead of 25 feet to the wall, 21 feet to the eave as required from the rear property line, regarding a 2-story addition and 1-story side addition to an existing 1-family dwelling in the R5 zoning district on the premise known as 1035 19th Street South. Staff recommends the board adopt the attached proposed resolution granting the use permit request with conditions, and I'd like you to please note that there is supplemental material for this case that came in after the application packet was assembled and printed.
Thank you, Mr. Rissy. Any questions for staff? All right. Are the applicants Mr. Monaco or Mr. Forrest with us?
Madam Chair,
Mr. Owen.
I did have a question for staff.
Go ahead.
Mr. Rissy, is this addition large enough that it would generate a review for stormwater management by the county?
I don't know that offhand, actually.
All right. Well, I'm happy to let the applicant speak while you look it up. And I'll just note that one of the supplemental letters we got from the rear neighbor concerns stormwater management, so perhaps the applicant can also speak to it.
So do we have the applicant with us, Mr. Monaco or Mr. Forrest?
Yes, Andrew Monaco here.
All right, there you go. I see you. Good evening. Welcome.
Good evening.
Is there anything you'd like to add on behalf of your application?
I don't want to reiterate what we already kind of have in there, but I will say that we applied back in August of 2017 and deferred modifications for comments from the board, and then were approved in September of 2017. We let that expire because we weren't prepared to actually do construction. We didn't pull a permit, and so we're just reapplying with the exact same application. Being to rear neighbor and the stormwater, we did talk with them. They felt they wanted to put that clause in there or whatever, change the wording a little bit of their approval, but we do have, and we said, you know, we had told them that they're concerned because there's 3 properties that kind of lead into their backyard, including the 2 neighboring right off of Kent Street. And so we did talk with them and explain to them that we were going to do all the stormwater management per the codes and work on that design. We didn't have that design yet to show them, but assured them we would share that with them at the time, and they felt that that was sufficient. And so then they gave us their approval. And that's all I'll say to that.
All right, thank you. Mr. Rissy, do we have any speakers on this item?
I don't have any who have signed up in advance, Madam Chair.
Are there any, is there anyone here that would like to speak on this item? Okay, so any questions for the applicant?
Madam Chair.
Mr. Owen?
Just to follow up on the stormwater issue, do you have a sense of, generally speaking, how you're going to approach stormwater management in the rear of the property?
We don't, like I said, we don't have a full design yet. And I guess, no, I don't. So I think our understanding would be that we would need some sort of, would possibly need a dry well or something like that. But I don't have that full design yet.
Would you be opposed to having a requirement in the use permit that you can, that you talk to the neighbor about your stormwater management before you implement it? And just to be clear, not for their approval, but just a requirement that you tell them about it and give them an opportunity to comment before you implement
it. No, we're not opposed to that. I mean, that's what we plan to do anyway. So okay. We will definitely be discussing it with them.
Okay, thank you.
Okay. All right, that's your neighbor at 1034 18th Street. I think. Is that the one directly behind you?
Yes, correct.
Okay, that's Mr. Mathura?
Yes, correct.
Okay. All right. Any other questions for the applicant? All right. Colleagues, any further discussion of this case? Okay, are we working on a motion? Has anybody got a motion they'd like to make?
I'm writing up a condition.
Thank you, Mr. Owen.
Mr. Rissy, does this project require a building permit?
Yes. Absolutely, the addition would require a building permit.
Madam Chair, I'd like to make a motion.
Mr. Owen?
I move that the Board of Zoning Appeals adopt the attached proposed resolution approving the use permit V-11592-20-UP-2, subject to the conditions listed in the proposed resolution, with 2 additional conditions. One, the 3-year time limitation that we've talked about. By the way, Mr. Monaco, that'll give you 3 times the time you had before potentially. But be careful, because there's also a county code requirement that could make it shorter. So you don't necessarily have 3 years, but you probably have longer than a year this time. And as well, an additional condition, the applicant agrees to provide the stormwater management plan to the rear neighbor and receive comments from that neighbor before the building permit is issued.
Second.
Seconded by Ms. Freshman. Any further discussion? I will call the roll. Mr. Owen?
Aye.
Ms. Freshman?
Aye.
Mr. Melnick?
Aye.
Ms. Clark?
Aye.
Chair votes aye. The motion to grant the use permit passes on a 5-0 vote. You have your project, Mr. Monaco.
Thank you very much. I appreciate your time.
All right, thank you. Mr. Rissy, will you call the next item?
Next item is case number V-11593-20-UP-1. It is a use permit request by Daniel McDonald and Lindsay Hauser, the owners, to permit a street setback of 16.2 feet to the porch, 15.1 feet to the porch eve, instead of 21 feet to the porch, 19.5 feet to the porch eve, as required from North Kenilworth Street. Regarding a new front porch addition to the R6, in the R6 zoning district on the premise known as 2505 North Kenilworth. Staff recommends that the board adopt the attached proposed resolution granting use permit request with conditions.
Thank you, Mr. Rissy. Any questions for staff? So is the applicant here, Mr. McDonald or Ms. Hauser?
This is Trip DeFalco, AIA. I'm the architect of the project. I do not believe that either of the applicants were able to attend the hearing tonight.
All right. Are you an agent for the applicants?
I am.
You are.
He's listed as the agent.
All right. Anything you'd like to add to the application?
No, Madam Chairwoman, I am here to answer questions.
Thank you. Any question? We have no speakers on this item. Is there anyone here who wishes to speak on this item that didn't sign up? Okay. Any questions for the applicant's agent?
Madam Chair.
Mr. Melnick?
So if there's no further questions, I'm prepared to make a motion.
Okay, Mr. Melnick?
Okay, so in case V-1159320-UP1, I move that the Arlington County Board of Zoning Appeals adopt the attached proposed resolution granting the use permit with the conditions as stated, including the 3-year provision that has been discussed.
Mr. Rissy, can you wait for a second or? No, okay, Mr. Rissy.
Before you move to a vote, I would just like to note for the record that Ms. Clark has stepped out of the meeting momentarily and she'll rejoin us, she said, in about 15 minutes, so she'll be unavailable for this vote.
Thank you. All right, is there a second?
Second.
All right, seconded. Motion made by Mr. Melnick, seconded by Ms. Freshman. Any further discussion? I will call the roll. Mr. Owen?
Aye.
Ms. Freshman?
Aye.
Mr. Melnick?
Aye.
Ms. Clark is absent. Chair votes aye. The motion passes 4-0 to absent. That's it. Thank you, Ms. You've been with us twice. I should know your name.
Thank you very much.
Mr.
I appreciate it.
DeFalco. Thank you,
Yeah.
Mr. DeFalco.
Right. Have a good night. Thank you.
Your label says general information.
Well, corporal punishment was taken.
That's right. There you go. Take care.
Bye.
Mr. Rissy, will you call the next item?
Yes, Madam Chair. The next item is case number V-11594-20-VA-1. It is a variance request by Robert E. Ford, the owner, to permit a main building footprint coverage of 31% instead of 30% as required for a one-family dwelling without a qualifying front porch or rear detached garage in the R6 zoning district, regarding a new elevated deck in the R6 zoning district on the premise known as 4928 25th Street North. And before I give the staff recommendation, I would like to note that there is supplemental material for this case that came in after the application packet was assembled and printed, and including an email from the applicant stating that they would like to withdraw the current variance request, but move forward with a modified use permit.
Okay, thank you, Mr. Rissy. Any questions for staff? All right. We have the applicant, Mr. Ford, I see is with us.
Yes, good evening, everybody.
Good evening. Do you have a comments you'd like to make?
Sure.
Madam Chair.
Should I proceed? I thought somebody was...
The chair seems frozen on my screen.
Oh, yeah.
I see that as well.
Let's give Ms. Malice a minute to reappear, and if not, we'll proceed with the hearing.
I hope it's not my presence.
I'm sure you're fine. Mr. Rissy, your hand is still up.
I just didn't lower it from before.
And actually, while we're on a pause here, perhaps we could issue the reminder about video usage for other spectators.
Yes, if there's anyone else in attendance, we would ask that you please turn off your video and microphone until your item is called. Thank you, everyone.
That might help free up some bandwidth from Ms. Malice. One moment. Yeah. Oh, I hear Ms. Malice. Are you back?
Yeah, I have been able to hear you all along, so I'm not sure what's going on.
You're back.
And oh, I see. I'm getting bad network quality. Can you hear me now?
Yes, ma'am.
All right.
Yes.
I have not missed anything. For some reason, you can't hear me, but I've heard you looking for me.
Okay.
But I'm here.
So
Mr. Ford,
I just wanted to clarify, when I was calling, it was actually not before. Maybe I was the one who caused you to freeze. But the point I wanted to clarify is we're having two hearings on this house tonight. The first is the variance, which is being requested for withdrawal, and then we will subsequently hold the hearing for the use permit. Is that correct?
Correct. Do I speak?
All right. Well, it looks like Teams viewer does not like my question and freezes Ms. Malice whenever I ask it. But I would say, Mr. Ford, please proceed to speak to the variance.
Okay. The staff at Arlington County, first I wanted to compliment their helping me out. First time I ever submitted an application of this type. Mr. Reese and Kamala, very helpful. I submitted the variance and I was requesting a building area of 31% instead of the 30% based on my initial design of the deck that I wanted, the deck extension that I wanted to put in the rear of my house. And I got the report, the recommendation, which was saying to deny, and that denial actually had me take a second and third look at what my design looked like, and I said, you know, I can meet that 30%. So I went back and modified my desired design and came up with something that I'm much more pleased with, and I can also respect the 30% variance. So
excellent.
So that's why. So there's been a change in design, And the way I've been able to meet the 30%, reduce it to from the 31%, is that I reduced the size of 2 existing decks. There's that you can see that the deck that you see that's a rear deck that's right next to my master bedroom.
Mm-hmm.
So my new design is that's 8.5 feet wide where you're looking. So my new design brings that to 4.
Mm-hmm.
So I saved some space there. And then there was another picture that showed the size deck. That side deck.
Mm-hmm.
That side deck is 6.5 feet wide. So I'm proposing to reduce that to 5 feet. And with those changes, I'm able to ask for the deck extension in the rear instead of going for a setback of 19.6 feet. I'm requesting a setback of 17.6 feet. That's in the new material that I provided today. And with these changes, I still have to go, I'd like to ask for approval for this with this new setback. And no more variance because I meet the 30% requirement.
Thank you, Mr. Ford. Mr. Rissy, do we have to act on the withdrawal? Or do we have to act to accept it? Muted.
Past practice has been to accept a withdrawal.
On a motion?
Yes.
All right. Is there a motion to accept the withdrawal? Ms. Freshman?
In the case of V-11594-20-VA-1, I move acceptance of the withdrawal by the applicant.
Second.
Seconded by Mr. Owen. I will call the roll. Mr. Owen?
Aye.
Ms. Freshman?
Aye.
Mr. Melnick? I believe Ms. Clark is still absent.
So I'll vote aye.
Thank you.
Sorry, Mr. Melnick. Chair votes aye. So the motion to accept the withdrawal passes on a 4-0 vote. So now, Mr. Rissy, you will call the use permit?
Yes, Madam Chair. In case number V-11594-20-UP-1, a use permit request by Robert Ford, the owner, to permit a rear setback of 19.6 feet to the deck instead of 21 feet to the deck as required from the rear property line regarding a new elevated rear deck in the R6 zoning district on the premise known as 4928 25th Street South. Staff recommends the board adopt the attached proposed resolution approving the use permit request with conditions. An alternative resolution has been provided should the BZA see fit to deny the associated variance in case V-11594-20-VA-1, without which the proposed rear deck cannot be built. Please note that there is supplemental material for this case that came in after the application packet was printed.
Thank you, Mr. Rissy. Any questions for staff?
Mr. Yes.
I do. So with these changes, Madam Chair, am I recognized?
Go ahead, Mr. Melnick, and then I'll recognize.
Okay. Does there need to be additional notice, public notice about these changes since it is a change in plans?
I believe actually there does. I'm looking at the proposed plans from today, and I wasn't thinking of it earlier, but 17.6 feet is less than 19.6 feet.
Yeah.
Since 19.6 was what was advertised. I do believe we will need to re-advertise with the new proposed setback distance of 17.6.
Any other, Ms. Freshman?
Well, yeah, I was going in that direction. So that would mean that we would defer to January, and then we would have the revised drawings presented in the staff report and measurements.
The deferral length is up to you. But yes, we would include what was today's supplemental material with the application when it comes back to you as the only set of drawings that there will be.
Right, excellent. Thank you.
Madam
Any,
Chair,
Mr. Owen?
I'll just note that we did not get any written neighbor feedback on this. And so with the extra time, it would be great if Mr. Ford were in a position to reach out to his at least 2 adjacent neighbors on either side. This faces the bike trail in the rear, so I don't think it's necessary to try and get the county's view on it. But traditionally, we do ask for written feedback or a petition signature or something from all neighbors. In this case, well, I guess the modifications to the side porch would also be visible from across the street. So just on the safe side, if Mr. Ford could make an attempt to get some written feedback from the adjacent neighbors, that'd be helpful in the meantime as well. Mr. Ford, is your property the one with all those lovely stone artwork by the trail?
Yes.
Those are terrific. I really loved reading them. That's a
We get a lot of people stopping by and taking pictures.
Yeah, it's really terrific. I love that.
Thank you.
Mr.
Can I
Ford,
ask a question?
do you understand what's happening here?
Yeah, that some letters from approval from the neighbors and updated drawings to reflect the changes.
Right, and we would have you come back in January, just, to see your drawings.
Is there no December meeting?
Our December meeting it's very close to the advertisement date. I don't think you would be able to get your materials in by then. And that agenda is pretty full already. So I think January is the most realistic one. I believe I'm correct about getting material. You'd have to have materials in like today.
Okay, I'm pretty close to that. The only thing I don't have today is the letters from the neighbors.
Yeah, I think, Mr. Rissy, are you shaking your head?
I was just going to say the same thing the applicant did. He actually does have material in today. It just came in as a supplement to this application.
Yeah.
Madam Chair, I know December's busy, so I'll defer to your judgment about which day, as chair, you think it best fits our schedule. But I think December is, from a logistical standpoint, it seems to me December is possible. And so I think it's a matter of, on which day are we going to be going past midnight because of our other cases?
Yeah.
Ms. Freshman.
Yeah, we already have an issue of appeals, which are extremely lengthy, and unless we don't know the disposition of those, if we set a time limit, it could very easily end up in January anyway.
Yeah, I think the more predictable date for you, Mr. Ford, is the January 13 hearing date. And then you'll be assured that you will get your hearing that day.
Okay. I'll mark it.
All right, so do we have a motion to defer?
Madam Chair,
Mr. Owen?
I move that we defer this item to the January 2021 Board of Zoning Appeals meeting.
Is there a second?
Second.
Ms. Freshman?
For the purpose of revised plans and neighbor comments.
All right. Yes, thank you for noting that. If there's no further discussion, I'll call the roll. Mr. Owen?
Aye.
Ms. Freshman?
Aye.
Mr. Melnick?
Aye. Aye.
What's going on?
I don't know.
I heard you say aye.
Yeah.
Okay, maybe I'm hearing it twice. Ms. Clark is absent and the chair votes aye. So the motion to, yeah, I am getting feedback. That's what it is. The motion to defer to January is adopted on a 4-0 vote with one absentee. Thank you, Mr. Ford.
Thank you.
Mr. Rissy, will you call the next item?
The next item is case number V-11595-20-UP-1. It is a use permit request by Giselle Zimmerman, the owner, to permit a street setback of 13.8 feet to the porch and wall, 12.8 feet to the porch and building eaves, instead of 25 feet to the wall, 21 feet to the porch, 21 feet to the building eave, and 19.5 feet to the porch eave, as required from 5th Street North, and to permit a side setback of 6.7 feet to the wall instead of 8 feet as required from the left side lot line regarding a two-story rear addition on a corner lot in the R6 zoning district on the premise known as 503 North Norwood Street. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions. I'd like you to please note that there is supplemental material for this case that came in after the application packet was assembled and printed. We also have an additional speaker who has signed up for this case. And lastly, I'd like you to please note that one of the proposed conditions is in conflict with the submitted plans and would need to be modified if the BZA sees fit to approve the application. The condition says that the porch shall not be built over, but the submitted plans show that the porch is built over.
Thank you for noting that. Any questions for staff? All right, is the applicant, Ms. Zimmerman, here?
Yes, I am. Can you see me?
I'm sure I will soon. There you are. Thank you. Good evening.
Good evening.
Is there anything you'd like to say?
Yes, I would like to thank the board for listening to my appeal this evening. I've lived in my home since 2004, and this renovation represents an opportunity for me to better align the home with how my family uses the space, and so I appreciate hearing this. In accordance with the guidance, I had reached out to my neighbors when we determined that we would need to be seeking a variance. And when I had those initial conversations, my neighbor, Beth Lewis, who resides at 507 Norwood Street, expressed to me some concerns regarding some screening trees that are on my side of our shared property line. And I've assured her, both verbally and via email, that I will do what I can to not only preserve those trees to the degree possible, including possibly relocating them somewhere else on my property during construction, or in the event that that's not feasible or that they don't survive, that I'm more than happy to work with her to find a suitable replacement. In a conversation we had yesterday, she'd actually indicated she'd been walking around the neighborhood looking at other screening trees that other people had used, and I told her that, you know, I'm more than happy when the time comes that we can work with a landscaper and figure out what would be a replacement if we don't want to use the exact same trees that are currently in the location. So other than that, I have received support from other neighbors. There was a question that Mr. Reese had sent to me regarding the property at 500 North Nelson Street, which is directly behind me. And I wanted to just note that the owner of that property, John Ritu, apparently passed away over the summer. I had reached out to his son, Brian Ritu, who lives in the neighborhood on Monroe Street, in order to find out how to contact his father, and was informed that his father had passed away. So Brian submitted a letter of support on behalf of his family with regard to the variance request and what I'm seeking to do.
Okay, thank you. Mr. Rissy, the speaker that we have signed up is Miss Lewis. Is that correct?
Yes.
All right, Miss Lewis, would you like to join us?
Sure. Well, I think basically I said everything in the note that I hope everybody's gotten a chance to read. I've lived in Arlington for about 24 years. And 12 years ago, we completely renovated my husband's family home from when he was 10. And that's where I reside now, which abuts Giselle's property in the back of her property. And that's where one of the variances is, where the trees are. And I do have concerned about the trees. There's 6 established, beautiful evergreens that have a lot of birds in them. But also, I'm just concerned in general with the limited space that is back there. And I did send Steven some photographs of the situation with the trees and how close Giselle's property is already, and next to my property line. And I'm not sure how they're going to be able to excavate and pour foundation walls for a basement with so little space without inevitably causing some problems. So that's, I mean, I'm really happy for Giselle to have a wonderful new house, but I am really concerned about this particular situation, and so I lean to your wisdom, and that's all I have to say.
Thank you, Miss Lewis. Yeah, we will apply our wisdom.
Thank you.
This is Seth Ballard. Can you hear me?
Mr. Ballard, can you identify yourself?
Yes, I am architect for Ms. Zimmerman.
All right, hang on. Good,
Okay.
good to have you here. Okay. Colleagues, are there any questions for the applicant that you want to ask now? Mr. Ballard may have something he wants to add. Mr. Owen?
I just want to ask the applicant, would you accept a condition to this use permit that requires you to maintain tree screening equivalent to what's there today?
To the degree that it's done in accordance and makes sense. Right now, I have a moisture problem on that side of the house, so I wouldn't want to create any sort of problems in that regard. But I would work with an landscaper to make sure that we have some appropriate screening in place. And I had even offered to Beth that if we, do something like some sort of trellising where we could do clematis or something flowering or something a bit more aesthetically pleasing, that was also an option. I'm happy to do.
Any other questions for the applicant? Ms. Zimmerman, I understand the trees are on your property?
Correct, they are.
Okay. And Ms. Lewis, is there room on your side of the fence for trees?
Well, if you look at the pictures, not really, because the trees are literally on the property line at the fence. So probably some roots are underneath my driveway there, but they are primarily on Giselle's property. Actually, before our husbands passed away, because both of us lost our husbands relatively recently, they had come up with an agreement where they would let us plant these trees as a green screen, in the back of their house. And I've maintained them all these years, and I've even cut out ones that were dying and beaten the snow off of the existing ones, and tried to maintain them. And they're very wonderful trees. They're very well established, but no matter what, I just have a really hard time trying to figure out how in that 6 feet we're going to do all of that. And it's very tight there.
Okay. This is where I think Mr. Ballard maybe can come in and help us understand the questions that Ms. Lewis is asking.
Yes. First of all, I don't believe that there is a way that we can actually remove the structure and build the structure that we're proposing to build and keep those trees intact. Those trees are potentially movable. And as Ms. Zimmerman stated, we plan on actually developing a landscaping plan to develop screening. And there are some narrower trees, I actually call them pancake trees, that we could do evergreen, where you can actually build them and they're thin, where we can reestablish a green screen there. Also, we can do like a flowering, we can do essentially a fence that has like bougainvillea or flowering plants, and we're happy to show basically whatever we're doing.
That's the picture of what she got.
to come up with a plan that she's happy with. But it would be a false statement to say that we would be able to excavate where we need to there and save those trees.
Okay. Mr. Rissy?
Madam Chair, just for the record, I would like to note that Ms. Clark has rejoined the hearing.
Thank you. I see you, Ms. Clark. Welcome back. Mr. Owen?
Oh, Madam Chair, I think I forgot to lower my hand. But I'm writing up a potential condition language based on the discussion.
All right. Any other questions for the, Ms. Lewis, did you raise your hand?
Yes, I did. I wanted to ask the architect, with so little room to work, how is that? I mean, I'm guessing the fence is going to have to go. I mean, I just don't know how you're going to do what you want to do in that space without literally tearing down the fence, tearing out the trees, and having to come onto my property, my driveway.
Actually,
it's so little space.
I've worked in much tighter quarters. We can put up a nice tall silt fence to control dust along the property, and the fence can stay in place, actually. I think ultimately we'd like to redo the fence and do something nicer. But in order to do the dig, we can actually do the dig essentially from the side when we remove the addition and remove the footings. We can actually work what's called concentrically with the footings, where we only need to dig 6 inches further than where the wall currently is. So we'll access everything from Ms. Zimmerman's side of the property. And it's part of civil engineering anyways, part of site planning work, that there will be those types of conditions, but we're also happy to, all of my contractors, we work closely with neighbors, just, it's never fun to have your next door neighbor under construction, but we do extra, things to try to, in fact, we can put up a taller fence there and put a taller silt fence just to try to keep dust off of your property. And then when it comes time to redo the fence, we'd like to work with you to just make sure that you're happy with the landscaping plan and that what gets put back is even better than what's there.
I really appreciate that. I'm not really worried about dust that I can think of. I guess I'm more worried about just how you're going to stay in that small area and if it will have any impact on my driveway or
not at all
like that. Okay.
Let me, Ms. Zimmerman, did you have a comment?
Yeah, I just wanted to note that I, feel that I'm very well placed to be really sympathetic to Beth's concerns. She underwent a significant renovation to her house while I was living in mine, and it took about a year. So I hear her concerns. I lived through her concerns when she did her renovation. So again, I feel that it places me to be quite sympathetic to the concerns that she's raising.
All right. Thank you. I think we're going to now limit the discussion with the board. I think Mr. Owen, or do you want to be recognized?
Yes, please. First, I have a question for Mr. Rissy. Will this project require issuance of a certificate of occupancy?
I don't know the answer to that question, but I'm getting a head shake of no from the architect. It does appear to be less than 2,500 square feet of land disturbance.
All right, so the last permit will be the building permit?
Correct.
Will there be a permit after the building permit? No, the building permit will be the last one.
Correct.
Okay, so this is the best I could come up with in terms of a condition. So hopefully, I don't think Mr. Rissy will love it, but maybe the applicant will accept it anyway. Applicant agrees to replace the vegetative screening in the location identified in the photo submitted to the BZA on November 11th, 2020, to a degree deemed equivalent by the zoning administrator prior to occupancy of the new structures.
Mr. Rissy?
You're right, I don't love it.
Can you live with it?
I'm sorry to interrupt, but there will it will be an occupied renovation. She'll be in the house when it's renovated, because half of that, 2/3 of the house is actually left as it exists. So the language would need to change.
Yeah, my hope was by saying occupancy of the new structures, that the implication would be, before you finish
You
and
leave.
occupy. I mean, presumably before you plumbed it, before you put the tile in and painted the walls, like that's what I'm meaning to.
So
talk.
with some slightly different language, the answer is yes, of course. It's just that language would be imply she wasn't occupying the structures.
The new structures. Do you have alternate language that we might use to suggest?
I think before a final inspection sign off is granted is fine.
Final inspection, okay.
Yeah, because that has to happen before a final inspection sign off can be given on the building permit. It's a required entity that Arlington County gives. So we could submit, documentation that we've done the screening. We're, as you say, I mean, we're agreeing to doing it.
Yep.
So,
Mr. Rissy, is the final inspection of the renovation a clearly defined term from your perspective?
Yes, it is.
Okay. So the revised condition would be applicant agrees to replace the vegetative screening in location identified in the photos submitted to the BZA on November 11th, 2020, to a degree deemed equivalent by the zoning administrator prior to the final inspection of the renovation. Mr. Ballard, does that comport with what you were hoping we would say?
very well said. Thank you.
Okay. And Ms. Zimmerman, is that okay with you?
Yes.
Okay. Thank you.
Mr. Owen, do you want to go ahead and make the entire motion?
I'm prepared if there's no further discussion to do that. Yes, ma'am.
I'll hear from Ms. Freshman.
Yeah, I just wanted to make a general observation. I think it's a really nice design on a very challenging lot. And what I'm hoping is that a 2004 survey is accurate, so that we don't have somebody coming back and saying they have to, they're 6 inches off or something like that. So that gives me a little bit of heartburn, but generally speaking, I like the project a lot, and I hope it goes well.
Thank you so much.
Madam Chair,
Mr. Owen.
I move that the Board of Zoning Appeals approve the attached proposed resolution approving the use permit V-11595-20-UP-1, subject to the conditions listed with the following modifications. I think condition number 2, that the words, except that the porch may be built over as shown in the attached architectural drawings. That an additional condition number 4 be included. Applicant agrees to replace vegetative screening in the location identified in the photos submitted to the BZA on November 11th, 2020, to a degree deemed equivalent, by the zoning administrator prior to final inspection of the renovation. And a 5th condition with the 3-year limitation that we have made standard for these.
Thank you, Mr. Owen. Is there a second?
Second.
Seconded by Ms. Freshman. Is there any further discussion? I will call the roll. Mr. Owen?
Aye.
Ms. Freshman?
Aye.
Mr. Melnick?
Aye.
Ms. Clark?
I want to abstain because I didn't hear all the case.
Thank you. And chair votes aye. So the motion to grant the use permit passes on a vote of 4-0, 1 abstention.
Thank you all so much.
All right.
Thank you very much. We appreciate it.
Thank you for all your input. That was very helpful. Thank you.
Thank you so much.
All right. Mr. Rissy?
Yes,
Would
the
you
next
call the
item,
next item, please?
the next item is case number V-11596-20-UP-1. It is a use permit request by Sherry Bennett and Gregory Flatt. The owners permit a rear setback of 10.9 feet to the deck from the rear property line instead of 21 feet to the deck as required, regarding a rear deck addition to an existing one-family dwelling in the R6 zoning district on the premise known as 4111 15th Street North. Staff recommends the board adopt the attached proposed resolution granting the use permit request with conditions.
Thank you, Mr. Rissy. Any questions for staff? Is the applicant, Ms. Bennett or Mr. Flatt, with us tonight? Ms. Bennett or Mr. Flatt?
Or Calder Kirk?
Or, yes, or the agent. I'm not hearing any response. And I'm looking down the roster of participants. I don't see those names. Normally, we don't proceed with the case if the applicant's not here.
Madam Chair,
Mr. Owen?
I would ask unanimous consent that we postpone consideration of this item to the end of the agenda or the end of the other cases in case there's a connectivity problem.
Is there any issue, Mr. Rissy?
I was going to suggest the exact same thing, and I'm going to suggest to the staff who are on here with me if they can try to reach the applicant by email to let them know that unanimous consent has been granted, if it is, to have the item heard at the end of the agenda.
I hear no objections, so we'll move this case to the end of the agenda and call it again. Thank you for reaching out to the applicants. That's very helpful. So in that case, Mr. Rissy, will you call the next item? And that would be Irving Street.
Yes, Madam Chair. The next item is case number V-11597-20-UP-1. It is a use permit request by Prime Custom Homes LLC, Ryan Fubini, the owner, to permit a side setback of 8.1 feet to the wall, 8.8 feet to the porch, 6.5 feet to the window well, and 5.2 feet to the airway from the left side property line instead of 10 feet to the wall and porch, 6 feet to the window well and areaway as required. To permit a side setback of 5.1 feet to the wall, 4.3 feet to the eave, 5.8 feet to the porch, 5.8 feet to the rear deck from the right side property line instead of 10 feet to the wall and porch, 6 feet to the eave and deck as required. And to permit an aggregate side yard setback of 13.9 feet instead of 18 feet as required. Regarding a new single-family dwelling in the R5 zoning district on the premise known as 1308 North Irving Street, and I'd like staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions, and I would like you to please note that there is supplemental material for this case that came in after the application packet was assembled and printed. And I would also like you to please note that we have additional speakers who have signed up to speak on this item.
Thank you, Mr. Rissy. Any questions for staff at this time? All right, no questions for staff. Is the applicant, Mr. Fubini?
Madam Chair?
Yes.
I do have some questions for staff. Sorry.
Excuse me. Mr. Owen.
The BZA is required to evaluate whether the proposal will not be in conflict with the purposes of the master plans and land use and zoning related policies of the county. This parcel is GLUP semi-public, i.e. zoning categories S3A and SD. The property abuts a church on one side and a church playground on the other side. The property is currently zoned R5, which is not one of the zoning categories listed in the semi-public under the GLUP. Is it a policy of Arlington County to encourage developers to rezone property to a zoning category compatible with the GLUP before receiving relief under special exceptions?
I can't speak to any policy of the county outside of the zoning office which I work for, and I can say that we do not often recommend rezoning to applicants who are submitting BZA requests.
But we don't get very many BZA requests where the zoning is incompatible with the GLUP.
Nope.
In fact, I can't remember one in the 5 years I've served.
Well, there's got to be a first, right?
Yep. Staff report indicates, thank you, Mr. Rissy. The staff report indicates that dwellings are permitted by right in the two zoning categories indicated in semi-public. However, this is not a variance application requesting permission to make the lot buildable for a dwelling. Rather, the BZA is considering the granting of relief for new construction of a dwelling with diminished setbacks, i.e., it seems that the BZA must consider whether the setback relief itself, not the fact of a dwelling, is not in conflict with the master plans and zoning and land use related policies of the county. Does staff have any guidance about how the BZA should evaluate whether the proposed setback relief on a single family home is or is not in conflict with the master plan and land use zoning policies?
I would say we did the same analysis for this single family house that we would have done for any of the other single family houses in the surrounding district. Obviously, if it were the church use that was coming to us this evening, they have different setback regulations, and we would have still had to evaluate that structure against the other structures in the surrounding area as we have for this structure.
Are these reduced setbacks compatible with semi-public uses on adjacent parcels such as churches and playgrounds?
Staff did not analyze the playground equipment, nor I think did we look at the setbacks for the church, though I would say that those lots are substantially larger than the subject property.
Okay. Those are my questions prior to the applicant's statement. Thank you.
Any other questions for staff? So is Mr. Fubini here, Prime Custom Homes?
Yes, ma'am, I am here.
All right. I'm looking for, do you have your, there you are. Okay, thank you. Welcome.
Thank you guys for your time. If possible, I have my, I'm a business owner here in Arlington, live in Arlington, etc. But I have my full-time architect on. He should be here and able to speak in regards to the project, the plan, and what I think are the most critical points. His name's Henry Brigham. If he could speak up for us here.
Yeah, hi guys, Henry Brigham here. I am the head design for Prime Custom Homes. I am kind of the thinker of this plan and probably have the best chance of telling you why we think it's important for what's happening. And I appreciate your guys' time, and I know that it's been getting late, so thank you so much for seeing us tonight.
All right. Any other comments on behalf of your application?
Sorry, I just had one question. I received that email a little bit late about I believe the GLUP, the master plan for Arlington, and it was a little hard to follow to some degree. But is the idea that is not having an effect in this hearing, or is it having an effect on this hearing? Sorry, just a point of clarity.
All right. Well, we'll find out.
Okay. Great. Thanks.
But yes, I can understand why that would be a question for you in your mind. Mr. Owen.
Yes. I'm wondering, can you tell us about your outreach to the neighboring I see in the supplemental packet that you have pretty thorough neighboring outreach to the abutting properties to the rear. But I'm wondering if you could please discuss your discussions or communication with the church that abuts you to the right and to the left.
Yeah, Mr. Owen, I'd be happy to. Actually, I believe Alice, who is the leader of the congregate there, might be on the line as well. It might have been too late. I'm not sure. But we have been in kind of a back and forth discussion on ways to keep the #1 priority, the kids safe who go between the church and the playground that's owned by the daycare. I think they're all kind of, connected, and how we can coordinate together in order to basically minimize any damage or any noise or dust or demolition. And so we've gone back and forth on different strategies as a team. We've met with Alice, a man named Hans, who is in development, who is part of the congregation there, as well as I believe the treasurer and the gardener. We've had a couple different meetings with them. They've gone up and down, and we've debated with each other about maybe best strategies here and there. And I believe we have their support at this point. We are, regardless of the outcome of this meeting, we're going to continue to talk with them, and we want it to be, the best for everyone. So regardless of this, we have their contact. We're going to talk to them after this, whether we are successful or not, just in order to go forward. And I think the only other neighbor we weren't able to get contact with was the owner of the property of the 4 units across the street, which we did track down an address, an elderly lady who owns that kind of like a condo, I guess, across the street, or the condo building across the street there that you see in that photo. And due to COVID, we have been dropping off packages everywhere of proposed, existing plat, what we think is the benefit versus, maybe not the benefit to some people, what we think we're bringing to the table in terms of, congestion on that road, aesthetics of the house, things like that. And we dropped off 62 packages across the neighborhood. And then we also made our own sign for support sheet with our email and different alternatives to give to us during this type of time period that we're all experiencing. So
thank you. It's helpful to hear about all that outreach. Appreciate it.
Yeah, we got to.
If you don't mind, I would like to speak up that I do believe we have the church's support. Otherwise, I believe they would be on here. We have a plan during demolition to work with them when the playground and preschool is closed, whether it is holiday, weekend, things have been discussed. We have also planned to provide a path on the back of our property so that the children are not having to walk around the church in front of the property, so that we don't have to worry about machinery, equipment, mechanics. We are going to provide a 6-foot tall chain link fence and give them a path on the rear side of our property to help with the church. We've also offered them financial or the ability to work with them to replace all wood chips, sand along in the playground area. This is not we've talked with them and we've kind of got it. Otherwise, they would be here and stating that they were not happy with the involvement. I think they are in support. The neighbor behind us have signed on for support, and as well as all the other neighbors, I believe are supporting what we're trying to do.
Thank you, Madam Chair. I'm ready. That's concludes my questions. I'm ready for the other speakers.
Okay.
Can we call the other speakers, please? All right, Mr. Schnarr, are you with us?
Hi, I'm Alice. I'm talking on behalf of the church. I'm the pastor.
I was calling. You're Alice
Toole. Yeah.
I have Mr. Mark Schnarr here. Is he part of your organization?
We're all, Mark and James are members in the church.
Are they here and do they wish to speak?
James is here. I'm not quite sure about Mark. James, I guess, could they unmute themselves and show themselves?
Yes, if they're here.
I'm James Fisher and I'm here.
All right, so Mark is not here. I'm looking at the list and I'm just going down first name, second name, third name. So Mark, I don't have Mark Schnarr here, so I'll go to James Fisher.
Thank you, Madam Chairman, for the opportunity. I've been a member of the church for 30 years, and I have coordinated my comments and my thinking with Alice, and I think she also will, Mark Schnarr has been involved in this project as well, has also coordinated his comments and thinking so that Alice can present them on behalf of the three of us. But I'm here and available to provide additional information if you need about our thinking on this project, our concerns about various things related to this project. So I can provide information if you need, but Alice's remarks will reflect my feelings.
Thank you, Mr. Fisher. That's very helpful. So you're it, Ms. Toole.
Hi, and thank you for this time, and thank you for your work, and Sorry it's so late. So I'm Alice Toole. I'm the pastor of Clarendon Presbyterian Church, and James is also here. And there's another member of our board who didn't sign up, but I think she's listening in. And I don't know if you can tell who's here from your side. But we have a couple more people on this. So Clarendon Presbyterian Church has had a presence on 1305 North Irving Street for about 100 years. And the Clarendon Child Care Center has operated from our facility for more than 50 years. Today, the school supports more than 40 students, and my daughter is one of those. We would note that while we understand the property rights of the applicant, the decisions made by the BZA allowing a large house to be built on our properties under a zoning exception will impact our own property and potential plans in perpetuity. This is a concern to us, and we ask that you take this into consideration. You're also likely aware that several churches in Arlington have considered or have enacted plans to transform their properties to benefit the larger community through affordable housing and other services, and any future opportunities that we may have to offer to the community would be impacted by this decision today by you, the BZA. So aside from that larger issue, as Henry was talking about, our major concern has been the safety of the children at the preschool during demolition and during construction, especially since these are COVID times and all of our windows have to be open in order for us to operate. These children currently walk past the applicant's property multiple times a day. So it's from 8 o'clock in the morning to 9:30 in the morning for drop off, then throughout the day, and then from 3 to 5 for pickup. So literally all day long. And they would be playing next to a demolition and a construction site. They'd be exposed to dust and debris and other dangers. And these are children 2.5 to 6 years old, as well as their teachers. And it is true, we have been in discussions with the applicant for solutions to address the safety and property concerns as recently as very late this afternoon. And we had a vote by our board this evening. And we have reached an agreement on measures that they will take to protect the children and our property. In light of that, we no longer need the additional 2-month delay that we asked to finalize the details of these important issues, and we would like to withdraw that request that we put in today for that 2-month delay. But we are also here, we are asking for your wisdom in what you all, in your expertise for this. So thank you so much for this opportunity to speak and to learn.
Thank you, Ms. Toole. So do I understand that you are not stating an objection to this project as it's proposed?
We are not asking for a delay as we initially did.
All right. Are there any other individuals here that wish to speak? I see some hands raised. So
I think James, oh, sorry.
That's okay. All I see is initials, so I'll just start with someone whose initials are HB. If you would like to speak.
Yeah, thank you, Mr. Chairman. Hi, Inta. This is Hans
Hello, Mr. Baumann.
Nice to see you all. And I appreciate Ryan and Henry having conversations with us and problem solving through our concerns. And I am glad that the church seems to be getting to a place of consensus and working out a path forward that they can proceed on. I do have a question for the BZA. In my conversations with Stephen Rissy, one of my concerns is that that aerial photo that's in the package is very good at showing the situation where there's currently a single family home at 1308 with no driveway and no parking on site. But because of the peculiarities of the R5 multi-use special zoning, whatever, you have to put 2 spaces on that lot. Now I see in this meeting here, routinely we're granting individuals and developers relief on setbacks. And yet it's my understanding that relief on the number of parking spaces on site is non-negotiable. Now, especially when I read the zoning code, it looks like once you've got a single family home, you can't go to a 2-family multifamily dwelling on an R5. So I guess I don't understand why we couldn't make the request, and I don't know whether Ryan and Henry would even be open to it. But I'm not clear why we couldn't request that there only be one parking space on that lot, which would reduce the required driveway width from a double wide driveway to a single wide driveway. And I guess I'm just not clear whether that's within the power of this board or not. And so as a citizen, I'm asking for some education here because I haven't been able to understand whether that would be a conversation that we could have with the developer and say, listen, it would be safer if there were a single driveway rather than a double wide driveway width on that lot. So does the BZA have the power, even though you can grant setbacks, can you not grant parking relief?
We cannot grant parking relief, is my understanding, or we would have, because we have had.
You're at the power to do so.
We've had cases where we clearly would have, where in fact there was ample street parking, and that complying with the parking requirement required the applicant to take down trees, which was very disturbing to everyone. But it is not within our power to grant parking relief. It's only with the county board that parking relief can be granted. And Mr. Rizzi, if I'm incorrect, you may.
And that's what Mr. Rizzi is summarized to me. I just wanted to hear it from the chair, so I appreciate your explanation on that. Again, I believe what they've come up with is an acceptable plan. I just wish there could be a slightly better parking situation, but I think they've done the best they could on a very small parcel.
Madam Chair.
Mr. Owen has a great deal of knowledge on the parking.
Well,
Arlington, so go ahead.
A very specialized situation. I just wasn't clear on one thing Mr. Baumann said. Is this proposed as a single family home? Or is this proposed as a multifamily home? Single family home. Okay, that was my only question. I guess this does potentially relate to my previous question, which is, should this parcel be rezoned to a compatible zoning district before development relief is granted? So I don't know what the parking requirements would be in S3A or whatever the other zoning category is. So they might be different.
Is R6 a zoning option, or are there only RA in this category?
There are no R zones permitted or in this GLUP category. And I don't know what the parking requirement would be. It might not be any different, but it could be different for a single family home located in an S3A or an SD, I guess, zoning category.
There could be a different requirement, or
yes.
So if this was an RA district, would this then not be in the purview of the county board? I mean, the BZA? Would it then be in the purview of the county board? That's for a staff question.
I assume that was to me. So it would still be under the purview of the Board of Zoning Appeals, but not as a use permit. Use permits are only applicable in certain.
But they'd have to come in as a variance.
They would have to come in as a variance, exactly.
And we don't have use permit authority within S3A or SD either, right?
Correct. It's only certain single zoning districts, R8, R20, R10, R8, R6, R5, and R27.
So we only have jurisdiction because this property is arguably miszoned.
I'm not making that argument, but okay.
And if they did, but they could potentially go to the county board for a county board issued use permit, maybe under those zoning categories, those other zoning categories. And the county board can issue parking relief. So that might be another reason why rezoning would be appropriate, because it would kick it away from the BZA into the county board, which could grant the greater parking relief. I'm not saying that's guaranteed, but I'm saying it's possible.
I'm sorry, Mr. Owen, are these zoning regulations for the GLUP defined at this point?
Yes.
Or is this, okay, they are defined, okay.
General,
I wasn't sure when that came into effect.
Go
ahead.
The zoning, the GLUP and the GLUP is very defined, and each category in the GLUP has very defined zoning categories that apply to each district in the GLUP.
Does anyone know when that happens, when that goes into effect, I guess, or like what the approximation might be of where that then applies to zoning? Because I know the zoning just switched here, right, in January. So I've never been in a district where it's like, you know, every year they switch zoning or the new plan
Your
does.
zone, how did your zoning switch?
Well, I think in January, at least some of the maybe I'm thinking of code. My apologies. Came back to Arlington after DC
Okay.
for a little while, but I thought something had switched with setbacks and kind of the requirements of those, and that were applied. Sorry, in January of 2020 or 1920. I don't know. Sorry. My apologies. I thought that the zoning had recently been established with the new, you know, revisions of it, but thank you.
My guess is that go ahead, Monica.
I was just going to ask Mr. Rissy, are you aware of any changes that happened in January that might affect this site?
No.
Yeah.
My guess, since this is outside of the Clarendon sector plan area, is that the GLUP for this has been in place for decades, and the zoning has been in place for even more decades, is my guess, for this particular parcel.
It seems that it's unlikely that there's been any immediate changes, but all right. Yes, we have some interesting questions about the zoning category. Are there other, Mr. Fisher, do you have your hand up?
I do.
Did you have a question for us?
I just wanted to provide a little more color and around a response that you asked of Alice.
Okay.
So two things, just to clarify the reason that we're talking about the 2 parking spaces and the concern about the danger is, while we've been discussing during construction having the children walk behind the house in a separated area, once that construction is complete, every day, multiple times a day, to access the playground, they will have to walk immediately past 2 parking spaces where somebody's going to be backing in and out of the street. And there's great concern among the operators of the child care center about that. So that's the specific issue related to why we're so concerned about the parking. The other piece is, you asked Alice, do we support this? You know, the point that she made was, if you look at that map, you see we have a large piece of property. We also own the brick house to the top of that photo, and we own the playground. You know, churches in Arlington, as she said, have looked for solutions for how we can creatively work to provide affordable housing or other things with parcels of land. We have not moved in that direction at this point, but clearly, just from the looks of that, from the nature of churches today in modern times, that's clearly something that could lie ahead. And so, you know, do we want a giant house on a postage stamp lot right next in between all of our properties? Not really, but we've sought advice from legal counsel. We've sought advice from folks who are familiar with the land use policies in Arlington County, and essentially, our understanding is that we don't have a whole lot of tools to prevent this from happening. And so, if you know, at best, what we've been trying to do is, as Mrs. Zimmerman said earlier in the evening, and her neighbor said in that case, you know, we seek your wisdom in this, knowing what we want to do. You know, we feel that we'd rather at least focus on the safety of the children and negotiate a path forward related to those issues with the developer, which we have. So thank you.
Thank you, Mr. Fisher. Indeed, you know, if this was a by right proposal, you would not have any say in it, but it is, you know, there is an exception is being asked. So the input of adjoining neighbors, abutting neighbors, is very valuable to us in terms of making our decisions. Did I cover, I covered all the speakers, I believe?
There's someone with their hand up,
I
Sarah Schwartz.
I have another speaker.
tried to put my hand up, but it's not letting me. I apologize.
No,
Can you hear me?
I see your, yes, you are.
Skylar Aarons.
Skylar Aarons, yes. Go ahead.
Okay. Yes, so I just wanted to touch base. I worked with Ryan and Henry, and I just wanted to reiterate a couple things on here, that they are trying to meet the intent of this zoning district as much as possible. I believe this house was built in 1910, so it too has been around for over 100 years. And I get there's kind of a mixed use here, but you know, from the aerial we saw, there's also single families that line the back of the property. So it's a pretty, you know, well woven area. You know, it's very unique. You have churches, you have apartments, we have, I believe, some commercial across the street. We have single families. I mean, it's just, it's very well integrated here. I just feel like it doesn't leave a lot of options for the developer if they have to try to do something by right. I think what happens is he gets stuck and pushed into a situation where something that's going to get constructed that's not as attractive, just to make sure that he doesn't, you know, have a financial loss or hit. And then we end up having something in the city that's honestly just not as appeasing, not as architecturally, you know, nice. And I think the opportunity here where we can get him to work with the neighboring church and make sure that the children are taken care of. And I believe there was other things they were willing to do with fence height and stuff like that, compromises they were willing to make. Again, with this district, it was really hard to meet a lot of the requirements. And I feel like they've worked really hard to do that. Currently, it doesn't have on-site parking, even though we really weren't pushing for the on-site parking. We achieved it to appease the zoning ordinance. We're meeting lot coverage requirements, and we're meeting, even though we're not meeting the initial 10-foot setback requirement, we are meeting what is usually one of the setback requirements, which is 8 feet. So I guess I just want to reemphasize that because I know we got jumbled up here in the beginning of the hearing and kind of missed emphasizing a lot of the good points and the big points for this request. Again, so we're meeting the initial one side setback that's usually required for the R5 district. We're adding increasing parking for the on-site that currently isn't there, so we're making it more compliant. Currently, if you look at the existing plats that were provided, there is more of an encroachment toward the side setback. So in reality, we're relieving some of the encroachments that are there now. You know, again, it's not the best situation. I totally get that. You can kind of tell by everybody's input and reactions. Everyone's trying to stay positive, but also kind of understanding we're tiptoeing around things. And again, I think this is the way we've kind of presented this is the best option to move forward, just because we are trying to make everybody involved happy. And again, the other alternative is if it doesn't get approved, then something perhaps less attractive gets built and less accommodations are made just because we're trying to prevent some type of financial hit here.
Mr. Aarons, I think your time is up. I'm not sure that the timer was up, but I was informed.
I apologize. Yeah, I didn't see anything. The little thing keeps disappearing.
Were you speaking on behalf, are you part of the development team?
Yeah, what's weird is, and I apologize, I thought I was automatically on the list to speak because I'm actually listed as the agent's applicant or applicant's agent on the initial application. Okay. So Henry was kind of taking the lead and helping out with some things. And like I said, I think we just got a little mixed up in parliamentary procedure. He and I did in the beginning. So
okay, got it. All right, Ms. Freshman.
Yeah, it's interesting as I've listened to the conversation. Everybody's trying to make themselves be comfortable with what we're looking at. And I don't think anybody is entirely comfortable. I don't see on the face of it why we necessarily would have an unacceptable and ugly project, even if it was by right. But I am concerned about the required parking. And yes, I wish we could do something about that. And children having to walk back and forth under what I consider to be unsafe conditions. The applicant has been forthcoming about an access for the children during construction. And apart from having a postage stamp backyard, which many houses in Arlington have, is there a reason why that safe access could not remain? So that the children would have a safe passage from the church to the playground permanently?
Sorry, I might be able to shed some light on that. So for multiple reasons, but one of the reasons is, as we all know, I think, and have dealt with, is liability. This is a private, enterprise to a home that will have a new family that has then had a 5-foot pathway taking out of an already teeny yard. Can I state that the house without the easement is going to be 17 feet wide, outside to outside? That's less width than the 2 parking spots we're providing. So with that 5-foot easement, or 5-foot, whether you do it where we gift it to them, or whether they get a deed for it, or whether we have contracts of limited liability, so if some kid falls or someone gets hurt on that they can't sue the private homeowner and the property owner of that. And we've been instructed by our council that's a big concern, I think. And I think people who have pools and have all the regulated, fences and everything can still be sued for someone breaking into their property and using their pool. And that's a concern, I think, for us to sell this property eventually to someone to say, hey, look, there is a 5-foot easement. Now, whether they want to keep it, I think where I grew up on Pershing and Jackson and Arlington. I've been here for 30 years. We had that arrangement with our neighbors. We had access with gates between yards, and I think that's a viable solution. But to put that as a condition that we are forfeiting 5 foot over 35 foot is a little bit extraneous at this point in time. And I think it is a legal issue, as well as what does that mean for our rear setback if it's separately deeded? Does our property line change?
The long story short of what Henry just said is there's 2 reasons. One is liability. 2, it's asking for 20 to 25% of our backyard of an entire property for a home that we're trying to sell. So there's 2 things: liability, and it's trying to give an easement or access for a property that is tiny. It is as everybody has already said, a postage stamp. And those are really the 2 reasons that it's not feasible. There were concerns initially where, hey, don't put a fence all the way to the end in the front of the street. And we said, absolutely, we agree. We'll pull the fence all the way back. We can put a mirror for them, or try to do something in regards to access, visibility in the future. But
Okay.
that was what we tried to do for it.
Thank you. Mr. Owen?
Yes, Madam Chair, we've had kind of a free-flowing discussion for the last 20 minutes.
We have.
And it's not clear to me whether or not we've worked through all the speakers. We have a number of citizens that have raised their hands, and I don't know what that means in terms of our process. So I just want some clarity process-wise about who we are going to hear from before we're ready for board discussion.
Thank you, Mr. Owen, because the hands keep appearing. Ms. Schwartz?
Yes, hi. Thank you for allowing me to speak. I'm Sarah Schwartz. I'm president of the board of directors for the Clarendon Child Care Center.
Okay.
As you've heard, we occupy a portion of the church's space, and I wanted to just echo some of the concerns that had been presented here. We obviously occupy a portion of the space and also use the playground that exists on the other side of the parcel. Our school is a full-day co-op preschool for children ages 2.5 to 6, and we cater to full-time working parents in Arlington. This is a very special school. It's been in the community for over 50 years and teaches children by encouraging exploration and play. And we also encourage community and creating a sense of community and being part of our community. As such, the children have always gone outside at least 3 times per day. But during this pandemic, especially, the children spend roughly 5 of 7 hours outside. Putting aside my overall concerns about demolition, construction, and general debris spilling over to the playground, if the parcel is developed as planned, the children, as you've heard, will be required to cross over this proposed driveway to walk to and from the playground. Currently, the kids travel on the sidewalk because the existing house has no driveway, as you've seen. So as board president, I wanted to just express my concern about the safety of the children with this proposal, given the numerous trips back and forth. And the easement on the back during the construction is certainly temporary. So we would be grateful if you would factor this safety issue into your consideration of the permitting for this project. Perhaps with more time, the developer could come up with a more creative and sustainable solution for the property, including when a new inhabitant moves in and not just during construction, to keep these children consistently safe when walking to the playground and back. I sense that an after-build solution undoubtedly could be rather onerous for the church and the school. But thank you so much for your time and listening.
Thank you very much, Ms. Schwartz. We have one more hand up, Anna Olson. Are you with us?
Hi, sorry, I was just unmuting myself. I am a member of the Clarendon Presbyterian Church Board, and I just wanted to reiterate that we have had concerns about, and I don't know what the BZA really can do or can decide about this, but with the windows needing to be open during COVID times for safety, I've been concerned about the children for their breathing with all the construction, but then also with COVID. So there's that, but also we're not asking for an extension on your decision. From our point of view, from the church board, we trust that you'll make your own decision on that. Anyway, thank you. Sorry if that's taking you far afield again.
No, thank you, Ms. Olson. It's very helpful. One of the difficulties I'm having with the app, there's 2 issues that I see and colleagues can throw out there. One is the appropriateness of this project in general, given the land use plans for this site. And the second is that, from my standpoint, that there's been a lot of offers of different mitigations, temporary, permanent, during construction. This is clearly the kind of thing that normally, in a commercial area, you would have conditions on. Because the next door neighbor is not another single family home, it's an institution. It raises an entirely different set of issues that are not normally part of a single family approval with conditions. I'm comfortable with all the promises that are being made that aren't documented, and I don't know that we can work all that out now. So I'm asking my colleagues now, strictly, I think I don't see any more hands, that we discuss among us. I see Ms. Schwartz has her hand, but I assume that's left over. I'm going to take her hand down and just talk among ourselves in terms of where we think that this project is, where we are as far as this project goes.
Can I have just 2 seconds very quickly?
No. No, I'm really moving it forward now. Yeah, everybody's spoken multiple times. We've been very generous, but I need to get a consensus of where we are, and then if there's questions for you all, we'll go back. So, any thoughts on where we think we're headed? And I don't. Anybody want to jump in and start, Mr. Owen?
Madam Chair, I think that the core issue here really does boil down to one of the things the BZA is required to examine, which is whether or not the proposal will be in conflict with the purposes of the master plans and land use and zoning related policies of the county. I've heard a lot of people presuming that the baseline here is that this needs to develop under R5. And I think that is likely a fundamentally flawed premise. I think that many of the issues that have been brought up about parking, about access, about its compatibility with church uses and playground uses on its other side, which are the expected uses under this club category, those are directly related to the fact that it's not zoned in accordance with the club. Earlier tonight, we had challenges because we had a religious institution that was located in a residential zone. On this case, we have problems because we have a residence located in a church designated club category. I suspect that if we go to the root of the problem, which is getting this property rezoned to a proper zoning category for this club, it's still allowed to be constructed as a single family home, but then we're into variance territory, or the county board may have authority to intervene, which frankly, for a complicated situation like this, they're used to that. They do this kind of stuff all the time, and we don't, and we're not as practiced at it and good at it. So I'm almost tempted to say that I'm not sure it's wrong to say that per se, the BZA should never approve a use permit for a zoning category that's misaligned with the club. I mean, I think that would be a classic case where the development is not compatible with the master plans and land use and zoning related policies of the county. That said, I wouldn't completely foreclose this. I mean, we just haven't really investigated that. I'll point out, and I don't mean to get too esoteric here, but the BZA is by state statute entitled to receive, not entitled, but expected or allowed to receive advice from the Planning Commission. And we've never done that before, but as we've just talked about, we've never considered a case where we have a zoning category that's misaligned with the club. We don't usually have authority to issue use permits in this club category. And maybe this is a situation where the Planning Commission should advise us. I'll note that everybody on my screen is frozen, so it's possible that I've been interrupted by my connection. So could someone please acknowledge that you can still see and hear me?
We can see you.
Okay. So I think at a minimum, we should investigate the first principles here, that we should defer this item for more feedback, at least from staff, from the Planning Commission, from the applicant, from the neighbors, about whether or not the possibility of rezoning this property would move it to people with better expertise on solving these problems.
Thank you, Mr. Owen.
I agree.
All right, Ms. Freshman. I don't see Mr. Melnick. I think he must be here somewhere.
Yeah, I'm here.
There you are. Okay, just want to make sure you're still with us, and Ms. Clark is with us. Okay, she's here. I see her.
Madam Chair.
Mr. Melnick.
For the record, I totally agree with Mr. Owen with his assessment. I think, a deferral is the most appropriate thing until we can get the feedback that he mentioned. So I agree with him.
So from the applicant's standpoint, is a deferral better than a denial?
Honestly, at this point,
wasn't a question. Just let me finish that. And it's really for us, because a deferral doesn't guarantee an approval. A denial then would make it clear in which direction the applicant needs to go. Do my colleagues see a flaw in that? Okay. All right. So, Mr. Fubiani, you can see our discomfort with approving this tonight. If you want to comment on that,
It's obviously, sad for me as a developer. Our timing, the timing and the delay makes it a business decision, a financial decision. Whereas the house right now and the setbacks were so close to the preschool, but the best thing for me as a business owner will be to do a non-conforming top over the home, and it's less appealing to everyone versus trying to do something that was working with everyone, including with the church, who, as you heard from all of the church members, were, or everybody except for the preschool, the person who ran the preschool agreed with it. And so we will probably have to go with, another route that's either non-conforming on a new construction home or build over non-conforming. And so I appreciate all of your time and effort, and I understand where you guys are coming from, but yeah, it's very disappointing to hear.
So a denial is a acceptable response as opposed to a deferral?
I guess I would appreciate the deferral as an option, of course, so that we can go back and analyze where it's, as I'm sure you guys can understand, it's all about financials, as well as obviously I care about Arlington. I am a neighbor to this community. I live in Ashton Heights. I build primarily in North Arlington. So a little bit of time would be, I guess, great as a deferral option.
All right. So we would need to, colleagues, we would need to sort of hone in what we think our expectations would be for a deferral period. Given the applicant's doubt as to whether this would be, whether it would be feasible to go through a lengthy rezoning process.
So I guess I'm not clear on whether or not the applicant has already ruled out seeking a rezoning. If especially since a rezoning might allow you to seek this permit just from the county board.
If that's feasible, I would love to hear from Stephen Reese. That would be amazing if that's really an option for us. I mean, my understanding with zoning, it is very restrictive on any rezoning. I mean, I guess it is a feasible process for us, but it's not. My understanding with zoning is I thought zoning is very, in my experience with Arlington zoning, is very cut and dry. There's not, like, the rezoning is not something that is a easy, simple, or even feasible process.
Also, in addition to that, if we did rezone, we'd be looking for a variance instead of a use permit, to what my understanding was.
No, not necessarily. That's
for the same size house that we're proposing now.
No. I'm saying something different. Okay. We only have, the BZA only has the authority to act in R zones. And an R zone is not the correct zoning category for this GLUP. Rezonings to align with the GLUP are supposed to be easy. That's the purpose of the GLUP. They are supposed to encourage developers to rezone their property to zoning categories that align with the GLUP. Once you had a new zoning category, it does not appear that anybody on the phone tonight knows whether use permits are available. But if they are available, they're not available from the BZA, they're available from the county board, who has much more flexible powers to do all the things that everybody would want.
Including parking.
Including parking, including a public access easement, all those kinds of things, the liability concerns, even, land swaps. I mean, there's like enormous number of tools available to the county board. So if we can get this out of the R5 zoning category into a different zoning category, which the GLUP, the county board's policy, calls for, it may or may not be possible for the county board itself to take over this project and be much more flexible with everyone than we can be.
Mr. Brigham?
Yeah, I'd just like to, I understand, you know, that it doesn't seem like we have an expert for what the next process is going to be. And that's fair. One thing I would like to say as a summary is that we have a plan where we're making a property more conforming than it is. We have the support of our neighbors, and it seems that what's held up is the potential for a possible rezoning when it's not required for everyone to be successful in this. And that we're deviating from the idea that this is a setback aggregate that we're actually getting more conforming to. We're making the front more conforming. We're providing parking, which I know is a security issue for the kids. And I think that none of us want to see anyone get hurt. We've never had anyone injured on any of our projects. And what we're doing is we're going to another avenue of making this process take longer into a point where no one's going to be very happy, I think, with the end conclusion, versus we've worked hard for months with the church, with our surrounding neighbors, and with the design to make an appeasing, functional house an otherwise non-functional property, and taking the place of a house that is in terrible ruins next to a church and a kid's playground. And I don't quite understand how we got here from that. And I don't understand what the judgment or how we can evaluate our position with hypotheticals at this point.
So you have I mean, we are suggesting that we have a deferral period during which time you can assess what your options are. You know, we're thinking that we're not the right venue. You certainly can come back to us if you find your options are not untenable, and see what we say at that time. But a deferral period would give you an option to talk to planning. You know, right now you're talking to zoning, and you know you would really be talking to planning for a rezoning to see, you know, what your options are there.
Okay, I just figured that everyone was in agreement in the neighborhood and us, and that we could proceed forward without making it more complicated. And is that people are happy with the proposed plan, and you guys are here in some light to serve the people of Arlington to some degree. And I know that's not entirety. And I think that the people in this neighborhood that affects are in agreement, and that's kind of what I see as the end goal here. I think that this could be approved and pushed forward, and then everyone would be happy, but it doesn't, I guess, based off what you just said, doesn't seem to be going that way. And that's too bad, because I think a lot of people put a lot of effort and are in agreement for the people it affects. And
I think that, you know, if we go if you end up deciding to go in another direction, you will build on what you've done so far. I want to get back to the conversation with my colleagues. Is there
Madam
any
Chair?
other comments? Yes, Mr. Owen.
So in the scenario where we're actually actively reconsidering the use permit at the BZA level, I appreciate that many of the speakers, I mean, to be frank, my sense is that people have been really pulling their punches tonight. I think there are concerns with this development, and nominally, some of the neighbors have said they're not asking for us to delay, but they're asking for some things from us. I mean, earlier tonight, repeatedly, we've added conditions to address neighbor concerns. And it appears that just hours ago, there was some kind of agreement in principle between the developer and the neighbors, which has not been reduced to writing and has not been proposed as conditions. So I would say that if the rezoning avenue is exhausted, that at a minimum, we should have in front of us written conditions that have been reviewed and that we have comments from both the developer and the neighbors that address the concerns that have been raised, including a review of possible access easement, a permanent access easement, as well as written conditions about the construction time promises that the developer appears ready to make. So even if we were headed towards an approval, which I'm not sure that we are, we might be, but we might be otherwise. I think a deferral would have been in order to get all those things written down. So that can happen at the same time. So while a different path to rezoning is being examined, if there turns out to be a majority of the BZA that's willing to vote for approval to avoid a by right R5 option, then that should certainly be presented to make sure it's ready to go.
Mr. Owen, I think we've exhausted this subject for the evening, and I'd like to move forward. And, I think we can try a deferral motion to see if that works. And if it doesn't work, then we will move on.
I'm
Mr.
prepared
Owen?
to make a motion.
Mr. Owen?
I'm defer this item to the January 2021 BZA meeting for the purposes of examining the possibility of a rezone of the property. And to examine conditions for construction mitigation, site access during construction, and child access post-construction.
I'll second it.
Seconded, motion made by Mr. Owen, seconded by Ms. Clark. Any other further discussion from board members? I will call the roll. Mr. Owen?
Aye.
Ms. Freshman?
Aye.
Mr. Melnick?
Aye.
Ms. Clark?
Aye.
Chair votes aye. The motion to defer has been adopted, defer to January. I think we've been pretty plain as to what we would be looking for. And Mr. Rissy can put you in touch with the appropriate people to discuss rezoning options so that you can become familiar with how that path would work.
Great. We appreciate your time, guys, and thank you for meeting with us. Thank you.
Thank you.
Thank you. Have a good evening.
Good evening. Mr. Rissy, will you call the next item, please?
Next item is case number V-11598-20-UP-1. It is a use permit request by Robert and Tracy Jefferson. The owners submit a side setback of 5 feet to the wall, no E from the left side property line instead of the 10 feet to the wall as required, and to submit an aggregate side yard setback of 14.9 feet instead of the 18 feet as required regarding a 2-story side addition to an existing 1-family dwelling in the R6 zoning district on the premise known as 801 North Illinois Street. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions, and I would like you to please note that there is supplemental material for this case that came in after the application packet was assembled and printed.
Thank you, Mr. Rissy. Any questions for staff? All right. Is the applicant Robert or Tracy Jefferson with us?
Hi, Rob Jefferson here. Hopefully my video will start.
It started. We see you. Thank you.
And I believe our architect is on the line as well.
Yes, I'm here as well.
All right. Go ahead, Mr. Jefferson. Do you have anything you'd like to add to the application?
I don't think so. We just want to thank everybody for hanging in there to review our application and thank the staff for preparing everything, preparing the package. Carter, I don't know if you have anything to add.
No, just reiterating what you said, and thank the BZA for your consideration.
And you are Mr. Carter Jones?
Carter Jones.
Okay, for the record. Thank you. Any questions of the applicant? All right. Just looking. Are we prepared for a motion? Yeah. Has everybody gone to sleep?
I'll make a motion.
Ms. Freshman,
I move the Board of Zoning Appeals approve the attached proposed resolution approving use permit V-11598-20-UP1, subject to the conditions listed, with the addition of the 3-year limit.
I'll second it.
seconded by Ms. Clark. Any further discussion? I will call the roll. Mr. Owen?
Aye.
Ms. Freshman?
Aye.
Mr. Melnick?
Aye.
Ms. Clark?
Aye.
Chair votes aye. Motion to grant the use permit is approved 5-0.
Thank you all very much.
Thank you.
All right. Sorry for the late evening. Mr. Rissy, will you call the next item?
The next item is case number V-11599-20-VA-1. It is a variance request by Richard and Kristen Whitney. The owners submit a maximum lot coverage of 39% instead of 35% as required for a one-family dwelling with a qualifying front porch in the R10 zoning district regarding an addition of new accessory structures, pergola, gazebo, swim spa, fireplace, and cooking equipment to an existing one-family dwelling on a corner lot in the R10 zoning district on the premise known as 3018 North Trinidad Street. Staff recommends the board adopt the attached proposed resolution denying the variance. An alternative resolution and conditions have been provided to the BZA see fit to approve the application as advertised. And I would like you to please note that we do have additional speakers who have signed up to speak on this item.
Thank you, Mr. Rissy. Any questions for staff?
Madam Chair, this is Paul Melnick.
Mr. Melnick?
So I'd like to initially note that on the disclosure statement, that neither one of the applicants is listed as having an interest in the property. It looks like they've only listed their mortgage company. And, this is, they're completely absent, really, on this one and then the next one. So it's in the grid where they're supposed to appear.
Right. I see that. Is that a fatal flaw or is that something that can be remedied?
Historically, we have sometimes allowed people to swear the true ownership if they're present at the hearing and correct the record afterwards.
Okay. All right, we will hold out that option. Any other questions for staff? All right, let's hear from the applicant. Mr. Whitney or Miss Whitney, are you with us tonight?
Yes, we are still here. With the late hour, I appreciate everyone sticking with us. I'm not sure what that was about with the I guess my engineer, whoever filled out the application, put the wrong thing down, why it has our mortgage company on there. So I appreciate you looking past that right now.
Mr. Owen?
If I could just ask Mr. Whitney, who owns your house?
My wife and I have a mortgage on it, but we own the house.
Does anybody else besides the two of you own the house?
No.
So you own it jointly, a married couple?
Yes, sir.
And nobody else has a lien on it or an interest or a right to buy it or anything like that?
No.
Okay.
Okay. That satisfies that question. So yes, we need to know who owns the house so that we know who we're granting the variance to.
Understood. I've listened to all the cases tonight, and that was the first one that came up like that, and I was kind of taken aback.
You thought you were prepared, huh?
Yeah.
All right. Would you like to speak to your application?
I would. Once again, thank you. I know it's late. I'll try to make this short and sweet. And with that in mind, I know we're this case and the next case. We were the last two cases, but I know one got trumped below us. But What I want to say really encompasses both cases. So while I know they're separately and there's, you know, process and procedures, hopefully that kind of streamlines the next one. So I'm not going to repeat everything I'm saying right now. Well, I appreciate the board taking the time to review our case, as well as the staff, you know, that's reviewed it up till now. You know, I was taught a long time ago, if you don't ask for a cookie, you don't get a cookie. So maybe the cookie I'm asking for here was a little too big. But, you know, I asked that the board, you know, really just consider, you know, not rejecting as a whole, but maybe consider asking, you know, approving a portion of a cookie, a smaller cookie that's more in line with what they traditionally see, you know, in their experience and wisdom in Arlington, what is acceptable, what gets approved, and kind of consider that as they look at this case. I realize my neighbors have opposed our request both in email, and I know you'll hear from them later. I consider them very good friends and even better neighbors. This has been kind of 2 years, been kind of kicking the can in this thing, and never really came to agreement, never really got in the nuts and bolts, but ultimately it seemed like, you know, the best thing was to just put it in front of the board, let the system work, apply, you know, they hear us, they hear them, and whatever happens, you know, happens. So, you know, there's really the one thing I want to talk about. I think, you know, the drawings are pretty good. Actually, this picture is really perfect. So whoever's controlling that, don't move it. The one thing I want to talk about is also their main concern, which has been water. You know, stormwater management. I heard it mentioned a couple times in other cases. That is their main concern. And really, even though, you know, the staff report said that granting this variance may not be a substantial detriment to the adjacent property, I actually feel to the opposite, that it's actually going to help the water system, you know, the water issue with adjacent properties. And, you know, by that, I mean, you know, what we're asking for in this first case is a larger roof area. So, you know, as you can see from this picture here, it's kind of sloped. You can see our backyard's kind of a plateau, and it slopes down in both directions. You can only see one. It slopes into the neighbor's yard. So obviously rain falling in our backyard will eventually make it, you know, into their backyard. The whole neighborhood kind of slopes that way. And then behind one of their houses is the stormwater management for kind of that block, so to speak. So by having a larger, you know, roof back there than what's allowed, I feel like I'll be able to collect more water, you know, gutters, and, you know, control the water and get it away from their property. So I consider that, you know, a positive thing. The second thing is being able to get it closer to the property line, which is the next case. And by doing that, as you can see, the sloped area is kind of the last 8 feet between our properties. By being able to move this gazebo, this roof structure closer to the corner, I'm able now to collect the water that would normally fall on that slope and head towards their yard. I'm able to, again, collect that, you know, get it away from their lots and, you know, get it elsewhere where it's supposed to go. And also with that line, by moving it closer to the corner of the property line, that frees up the middle of our property. It's not a big area back there. As you know, we're a corner, so we got the 225 setbacks on each side, so we're kind of pushed back in the corner. By being able to move the gazebo to the corner, it frees up space in the center where we're able to step down. I think 3 steps is the plan right now, which will essentially lower the overall height of the gazebo, which means it'll be less visible from both their yards. As you can see, they both have fences, but, you know, this should reduce it by 2.5, 3 feet, you know, probably cutting what they see from their size in half. So all those things I kind of looked at as a positive, you know, which would be a good thing for them and benefit them. Obviously, they don't feel the same way. You know, they're here, which I totally respect. But, you know, really, that's just our position on it. That's really what both cases come down to. You know, in closing, again, I'd just like to ask the board to consider, you know, not rejecting this as a whole, but maybe approving a portion thereof, what we're asking for, in which case then we would, you know, design in detail according to whatever, you know, leeway we're given, and then, of course, submit for a permit. But you know, it's been a long night. You guys have talked a lot of stuff, and a lot of things were talked about. And you've kind of gone round and round. I know my head's spinning, but my dog's awake now apparently. But whatever decision you come up with, we're going to respect it. We're going to accept it. We're going to move on. Speaking for my side, my wife, we'll move on. You know, and lastly, I just want my neighbors to know, you know, no matter what happens here, you know, this isn't going to affect our friendship, our relationship. My daughters are best friends with their daughters. I'm sure if I did anything to disrupt that, they wouldn't talk to me anymore. So, you know, that's kind of just where we're at. You know, let the system work.
Thank you, Mr. Whitney. Any questions now, or shall we go to the speaker? Mr. Rissy, I lost the list. So Mr. Blackwell, I assume, does not wish to speak except for questions. I don't know if he's here. So the next speaker is Mr. Agnew. And I don't see him, and I don't hear him. Mr. Agnew, are you with us?
He should be here. I see his number on.
You see his phone number?
Yeah, I see him on there. He's on mute.
Mr. Rissy, how does somebody take themselves off mute by
I
phone?
think it's *6.
We cannot unmute people.
Who's with him?
There we go, unmuted. Mr.
Right.
Agnew?
Mr. Agnew, are you with us? Going once, going twice.
I saw the mute go away.
I see the mute. Yeah, the mute has gone away, but I don't hear him.
Hey, y'all, can you hear me?
Now I hear you. Are you Mr. Agnew?
Sorry. I am. I profess to be a technologist, but obviously not.
All right, well, you made it.
Listen, thank you all for working through the night. I know it's a late one. I would echo Rich's sentiments that none of this will come between our friendships as neighbors. My main concern is water. I know that's not your primary function at the zoning organization, but it is certainly one that concerns us. Also, any elevation issues also concern us. I did forward over a picture of the backyard to one of y'all tonight, hoping that it would be presented. We have a 6-7 foot privacy fence on the property line. The Whitney's home was elevated, or the backyard was elevated by 3 feet. With a no permit retaining wall, which then extends another foot or foot and a half above that very shortly, and basically a 45-degree slope. So the backyard is, comes out to be about 2-3 feet below our privacy fence. We worked really hard to plant trees that are going to, shade, give some kind of privacy on our R10 lots that used to be for, 1,200 square foot ramblers when we moved in. And we, both Rachel and I, understand the need for progress and the need for, growing families. Sorry?
Sorry, I didn't mean to interrupt, but I'm supposed to give a notice when you have 30 seconds left.
Oh.
I also want to let you know that I
much.
put the picture up for you, because I know you can't see it on your phone.
So, you see our view. Our main concern is a large roof and a chimney and, whatever else, 5-6 feet up in the air above the privacy fence. It's just, it's a detraction from the house, along with, whatever other water concerns. And, we're not sure that an approval by the zoning board means that there won't be the same kind of scrutiny by DES that comes with building a new home, which, anyway, thank you for hearing me out.
Thank you, Mr. Agnew. If there's no, I have someone, is there another speaker here that wishes to speak on this item?
Yeah, this is William Benston, another one of Rich's neighbors.
Okay.
If you don't mind, Madam Chairman.
Yes, please.
Yeah, so I'll just echo again what Rich said. We are very close friends, family, very close family friends, have been for 30 plus years with the Whitney family. So I don't want to make this any more arduous than it is, but we are his direct lot line neighbor on the side where he is committed to building right up against the lot line, which obviously as the owner of 3012, I have to protect my property interests, which is anybody coming to purchase my home and looking at the setback that I have against the property line, and then a large pergola attached to a large roof that has gutters and or soffits that hit about a half foot away from my property line is not only a water concern, which it is, and I've talked to Rich at length about my water concern. I also have a concern about ultimately that property line, the adjustment to being that close to the property line and what it does to encumber my lot in the transaction of a sale. So that's number one. Number two, I want to clarify, and again, I don't do this to harm Rich, but Rich and Kristen were the builders of this home. So at the time that they built this home, I think the restrictions around an R10 corner lot were well known. And so my opinion of the variance attempt here is to circumvent a process that is designed to not have allowed this during the actual build process, which obviously would have held them up in a permitting process or a rezoning process or whatever you want to call it at that time. So I want to just make sure that the board is aware that from our seat, again, this isn't personal between the Benstons and the Whitneys or the Agnews and the Whitneys, but the Agnews and the Benstons, both representing his direct property line owners, vehemently disagree with both of the requests that are being made.
Mr. William, what is your last name?
Benston.
Benston.
B-E-N-S-T-E-N. Yes.
All right. You're just showing up as William, so I want to make sure that we got your name.
Sorry about that.
That's fine. That's fine. We take care. All right. I don't believe there's any other speakers. The discussion is with the county board, with the BZA.
Madam Chair.
Mr. Melnick.
Okay, so in this case, just like the other ones, we have, criteria that we have to look at to see if it's met. And I believe there's at least 3 that are not met. And of course, the main ones are, does this, would the strict application of the terms of the ordinance unreasonably restrict the utilization of the property? And I just don't think it would. What we're talking about here, it just, to say that there's got to be compliance would not unreasonably restrict the use of the property. It would not, and it also would not create a hardship because, as can be seen from the staff report, this is not a small lot. It's actually on the larger side, and it's comparable to surrounding lots. There's not a disability claim, and also it's general and recurrent. And so I'm just, with what's being proposed, I'm just not saying that by preponderance of the evidence these criteria have been met. It hasn't been shown that that a variance should be granted based on this. So based on that, I can't support it.
Thank you, Mr. Melnick. Ms. Freshman?
Yes, I think that I agree with Mr. Melnick. I was just looking at the plan. It seems like there's a lot of things that are going to be added into this small space. And I know the applicant said we could sort of say what's good and what's not, but we don't plan things. I mean, they can get staff guidance, but we don't plan things, and especially ad hoc like this. Water issues, of course, can be addressed and should be addressed. But I think once again, we're seeing an example of a new home being built to the maximum allowed, which affords, whether or not, in this case, apparently, according to the neighbor, the applicants built the house. We've seen other cases where a developer built the house and then the purchaser comes in later, wants to add something, even something much smaller than this proposal, and they can't because it's already been built to the max. So that was a choice. And that, now it's coming back to bite them in the sense that trying to add a whole bunch of anything, or even just a small deck, or, wouldn't even have to be this extensive. We're seeing this, we have seen it more than once. And unfortunately, that can't make an exception after the fact like that. Any other comments?
I also agree. The criteria for a variance are very, very strict, and I don't think any of the criteria have been met on this application. And I do want to say one thing. Neither the testimony of Mr. Benson or Mr. Agnew swayed my decision. It really is based on the facts and not neighborhood input in this case. So I just say that you know, good neighborly relations can continue. But in order to do any of what the applicant is asking, he's going to have to find a way to do it without exceeding the maximum lot coverage. And if he can do that, he doesn't have to come back here at all and see us. He can just do it by right. But it will be upon, you know, incumbent on him to figure out how to stay within the required lot coverage. Any other comments? Ready for a motion?
Madam Chair, I'll make a motion.
Mr. Melnick?
Okay, so in case V 1159920VA1, I'd move that the Board of Zoning Appeals adopt the attached proposed resolution denying the variance.
Second.
Motion made by Ms. Melnick, seconded by Ms. Freshman. Is there any additional discussion? I will call the roll. Mr. Owen?
Aye.
Ms. Freshman?
Aye.
Mr. Melnick?
Aye.
Ms. Clark?
Aye.
Chair votes aye. The motion to deny the variance has been adopted on a 5-0 vote. We have, Mr. Rissy, a supplemental item to handle here.
You still have the next item, Madam Chair.
Yes, I'm asking you to call it.
Okay. Case number V-11599-20-UP-1 is a use permit request by Richard and Kristen Whitney, the owners, to permit the following. Side setbacks of 1.1 feet to the accessory structures, gazebo, fireplace, and swim spa instead of 8 feet to the side property line. Rear setbacks of 1.5 feet to the accessory structures, gazebo, fireplace, pergola, and cooking equipment instead of 10 feet to the rear property line, and to have an encroachment of 1 foot for the gazebo and pergola to the side and rear property lines instead of 5 feet as required. Regarding the addition of new accessory structures, pergola, gazebo, swim spa, fireplace, and cooking equipment to an existing one-family dwelling on a corner lot in the R10 zoning district on the premise known as 3018 North Trinidad Street. Staff recommends that the board adopt the attached proposed resolution denying the use permit request. An alternative resolution has been provided should the BZA see fit to approve the application as advertised, and I will note that we had speakers who had signed up to speak on both this and the associated last variance.
All right, Ms. Freshman, do you have your hand up?
Well, I'm prepared to make a motion, but I can put my hand down temporarily.
All right, well, I think is there anyone that wishes to speak on this? Since we have denied the variance, it's not possible to adopt this use permit. If we have no one speaking on it, Ms. Freshman, you have the floor.
Thank you. I move the Board of Zoning Appeals approve the attached proposed resolution denying the use permit V-11599-20-UP1.
I'll second it.
Seconded. Motion made by Ms. Freshman, seconded by Ms. Clark. Any further discussion?
Madam Chair,
Mr. Owen.
I'll just add that, like you, even before I had heard anything from the neighbors, I thought this was a very clear-cut case. And so everyone can be assured that it was decided on the paper, as it were.
I completely agree. And it sounds like everybody's still was friends, and I hope they stay that way. I will call the roll. Mr. Owen?
Aye.
Ms. Freshman?
Aye.
Mr. Melnick? Ms. Clark?
Aye.
Chair votes aye. Motion to deny the use permit carries on a 5-0 vote. We have one remaining item that we had called before, and we're looking for either Miss Bennett or Mr. Flatt or their representative. Are they here? Do you want to recall the case, Mr. Rissy, just so that we can act on it?
Yes, the case is case number V-11596-20-UP-1. It is a use permit request by Sherry Bennett and Gregory Flatt, the owners, to permit a rear setback of 10.9 feet to the deck from the rear property line instead of 21 feet to the deck as required, regarding a rear deck addition to an existing one-family dwelling in the R6 zoning district on the premise known as 4111 15th Street North. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions.
Thank you, Mr. Rissy. Any questions for staff? All right, it's our practice usually. Ms. Freshman.
I just wondered if, it's been a long time since we've had a no-show. Do we defer, do we deny? What's the,
We have, all of our options are open. We can
Okay.
also approve. But it's been typical that we would wait for the, we would give the applicant a chance to join us before we make a decision, unless we feel strongly one way or the other.
Last time this happened, I was ready to deny and they didn't show up and they got an extra month. So this one, on the other hand, this one I was leaning towards approval, so I'm willing to wait.
So we defer this item and we can find out what happened to the applicant. Is that a,
Madam Chair, so I'm in favor of deferral.
all right, you want to make a motion, Mr. Milner?
Sure. So is it January meeting?
Yes.
Okay. Let's see. So in case V1159620UP1, I move that the Board of Zoning Appeals defer this matter until the January Board of Zoning Appeals meeting.
Second.
Seconded, motion made by Mr. Melnick, seconded by Mr. Owen to defer to the 13th because we have no applicant present.
Okay.
Any further discussion? I will call the roll.
Oh, Madam Chair.
Yes, Mr.
I would just note that the this is another one where the comparables in the staff report are really far from the property. And the applicant has noted that their next door neighbor has a deck in their backyard that's very close to the rear property line. And so I would love it if we could get more information about the properties immediately surrounding the parcel in question, if that's possible.
Ms. Freshman, do you have your hand up?
sorry.
That's okay. Mr. Rissy, I wonder if that's the case, why you would not have a plat on file for it. If it had a setback that required a BZA action to build, why there wouldn't be a record or a plat that would support that.
Madam Chair, it may be that we have a plat, but it may not have been available to the staff writing the report.
Okay.
Most of the old applications are in cold storage in the basement of the office building, and as most of us are working from home, are not available when we're writing.
Okay. Thank you. Any further discussion? I will call the roll. Mr. Owen?
Sorry, I was on mute. Aye.
Ms. Freshman?
Aye.
Mr. Melnick?
Aye.
Ms. Clark?
Aye.
Chair votes aye to defer this matter to the January 13th meeting. Next order of business is two sets of minutes, one from September 30th. We've all had a chance to review and input these. Is there a motion? Ms. Freshman?
Do we need to approve each one separately?
Yeah. No?
Okay.
Yeah,
They can be together. It can be one motion.
all right, so let's move both of them.
I'll move approval of the minutes of September 30, 2020 and October 14, 2020.
Second.
Seconded by Mr. Owen. All in favor, I'll call the roll. Mr. Owen,
Aye.
Ms. Freshman,
Aye.
Mr. Melnick,
Aye.
Ms. Clark,
Aye.
chair votes aye. Minutes for the last two meetings have been approved. I think we had, Ms. Freshman?
Before everybody departs, we've had some discussions about the length of meetings and how we're trying to adjust accordingly. And I just wanted to do a brief summary of this evening. According to our agenda, we had 16 items. And number 13 ended at 10:35. And several of them were really quick. And the last case ended at 11:05, and that was a no-show. So that was even quicker than the other quick ones. And I only say that because I think that as we have many deferrals and as agendas come in that where we don't know how many items we're going to have, and especially with 2 appeals coming up, I'm very concerned about the length of the meetings. And if tonight is an example. And I had suggested at one point in one dialogue that we look at some way of cutting off at a certain point, like not starting after 10 or something like that. And I don't know that that's practical or feasible, but I just wanted to point out that we had a couple of items that took a little bit of time tonight, but we also had several that went really quickly because they weren't controversial. We can't always count on that being the case, even if we only have 10 or 12 items on a given agenda. So and I understand that staff resources are limited and a second meeting every month is probably not feasible. But somehow or other, we need to get a handle on this because it really feels like we're getting into the territory where 11 or midnight is going to be the norm. And I find that a little bit difficult to manage.
Thank you, Ms. Freshman. Mr. Owen, did you have something you wanted to raise as well?
Yes, I'll just say that I'm very sympathetic to Ms. Freshman's comments. But I have circulated by email to staff and to the board members a proposed revised financial disclosure form that hopefully will be easier to fill out and make fewer mistakes on. And so I'd like to ask unanimous consent to list that new form on the website for the December BZA meeting for adoption to allow the public to see the form and potentially comment to us about it before we would adopt it potentially in December.
Is there any objection to Mr. Owen's proposal?
No, and thank you very much for that, Peter. I thought it was really great and appreciate your focusing on it because clearly we have, at every meeting, we always have at least one application that has an issue, sometimes several. So it's a noble goal and I hope it works.
Thank you, Judy. And I also want to thank Stephen, who had 2 phone calls with me to try to help improve it. And that was very welcome. So I want to thank him as well.
Mr. Ricci, you have no problem putting it up on the website for people to see?
No.
Okay.
I'll add it to the agenda that is advertised in the newspaper as well as it has not been distributed yet.
That would be excellent. That we'll take it up at the end of our meeting.
Just sorry for point of clarification since we're talking about it. Is it okay that we put that at the end of the agenda or is there?
Yes, at the end.
At the end.
Right there with the minutes.
All right. Anybody else? Go ahead.
Just the other thing I would say, I think, I'm not sure if we're settled yet on how we're going to handle these appeals, but I would note that we're not permitted ex parte communications on the appeals. And so I think, and appeals can be quite complicated. So I just while I doubt we will have time to debate the appeals at the December meeting, I would say that if we could at least provide an opportunity for the parties and board members to list the questions that they would want to have discussed at the actual deliberation when we're allowed to do it, because the only spot we can do it is when we're all convened like that. I would just say that that might really make the actual consideration much more efficient and reduce the chances that we would hear them only needing to defer them for lack of some critical piece of information.
All right. Yes, we're working on that, but I think that's a good suggestion. If we can't hear them in their entirety and act on them, that at least we get any questions that we have out on the table. I think I'll get back to Mr. Ricci. You know, we need to get back to Mr. Ricci before the end of the week. So if there's any other feedback you want to give me on how we proceed in terms of when we would cut off our cutoff, you know, if we have a firm cutoff time, what that time would be, so that we can potentially, that we all know where we're going, and that we can potentially let applicants also know where we're headed, so that they're not surprised that we're not staying up till 1 o'clock in the morning to hear their case. All right.
This is volunteer work.
Yeah, well, you know, it's a labor of love, right, Judy?
Oh, yeah. 30 years.
I was talking to one of the Fairfax BZA members a month and a half ago about some of their administration, and he was shocked to find that we were volunteers that met at night. He couldn't imagine what that must be like. They're all paid and they meet during the day.
There's something in the water that makes people in Arlington step up and do these things.
It's the shadow government. They think they have budget problems now. Imagine if they had to pay for all the expertise.
All right. Well, with that thought, I believe our agenda has been completed and this meeting is adjourned.
Thank you. Good night.